Almighty God, the most beneficent, the most merciful, we give thanks to you, the creator of the universe, and humbly beseech you to direct and prosper the deliberations of the members of this House, here assembled for the advancement of your glory and the trust and welfare of the people of Trinidad and Tobago. Grant that peace and happiness, truth and justice may be established among us for all generations.
Announcements by the Speaker.
Honourable members, I have received communication from Mrs. Camille Robinson-Regis, Member of Parliament for Trin-City Maloney, who has requested leave of absence for the period October to December 31st, 2025. The leave which a member seeks is granted. Honourable members, correspondence has been received from the President of the Senate dated September 30th, 2025, which speaks as to changes in the membership of the Joint Select Committees. And the Honourable President says, reference is made to the subject matter at caption. At a sitting held on Friday, September 26th, 2025, the Senate agreed to the following resolution. Be it resolved that the Senate agree to the following appointments to the Joint Select Committees. On land and physical infrastructure, Miss Sophia Choate of Senior Counsel, in lieu and in replacement of Mr. Derup Timal. On foreign affairs, Mr. Anthony Vieira of Senior Counsel, in lieu of Mr. Francis Lewis. And on Public Accounts Committee, Mr. Francis Lewis, in lieu of Mr. Derup Timal. Accordingly, I respectfully request that the House of Representatives be informed of this decision at the earliest convenience, please. Respectfully, the Senator, the Honourable Wade Mark, President of the Senate.
Papers.
Minister of Homeland Security.
Good day, Mr. Speaker. Mr. Speaker, I beg to move. Sorry. Mr. Speaker, the nomination of Her Excellency, the President, in respect of the nomination of Mr. Junior Benjamin, Deputy Commissioner of Police, for appointment to act in the office of Commissioner of Police. And also, Her Excellency, the President, in respect of the nomination of Mr. Kurt Simon, Assistant Commissioner of Police, for appointment to act in the office of the Deputy Commissioner of Police.
Honourable Attorney General.
Mr. Speaker, I have the honor to lay the Mutual Legal Assistance in Criminal Matters Declaration of Treaty Number 2, Order of 2025.
Minister of Finance.
Mr. Speaker, I have the honor to lay the following papers. Paper number 4, the executed loan agreement between the Republic of Trinidad and Tobago and the Cooperación Andina de Fomento to finance the project to strengthen digital infrastructure in Trinidad and Tobago through the establishment of Tier 4 Data Center dated August 7, 2025. Paper 5, the report of the Auditor General in the Republic of Trinidad and Tobago on the non-receipt of financial statements of the Diego Martin Borough Corporation for the years ended September 30th, 2009 to September 30th, 2024. Paper 6, the report of the Auditor General of the Republic of Trinidad and Tobago on the non-receipt of the financial statements of the Sangre Grande Regional Corporation for the years ended September 30th, 2015 to September 30th, 2024. Paper 7, the report of the Auditor General of the Republic of Trinidad and Tobago on the non-receipt of financial statements of the San Juan Lavatil Regional Corporation for the years ended September 30th, 2018 to September 30th, 2024, and the audited financial statements of Trinidad and Tobago Nitrogen Company Limited for the financial year ended December 31st, 2024. Mr. Speaker, I beg to move that papers 5 to 7 be referred to the Public Accounts Committee and paper 8 be referred to the Public Accounts Enterprises Committee.
Honourable members, the question is that papers 5 to 7 be referred to the Public Accounts Committee and paper 8 be referred to the Public Accounts Enterprises Committee. All in favour say aye. Aye. Any against? The ayes have it.
Urgent questions.
Member for Aruca Lopino.
Thank you very much, Mr. Speaker. To the Minister of Defense, in light of the current state of emergency in Trinidad and Tobago, can the Minister give the reasons for the sudden termination of the Chief of Defense Staff?
Minister of Defense.
Mr. Speaker, permit me to invoke Standing Order 27G.
Member for Aruca Lopino.
Thank you very much, Mr. Speaker. Mr. Speaker, the purpose of this exercise is to get information.
No, hold on.
Thank you very
He's
much.
putting a preface to his question. I would imagine that the question will come. So let's just give him, it's one question, we have 15 minutes. I'm sure he's going to.
Thank you very much, Mr. Speaker. Mr. Speaker, the purpose of urgent questions and questions in this Parliament is to hold the government to account on critical matters of governance in Trinidad and Tobago. And therefore, Mr. Speaker,
Okay. I would imagine that there is some justification for you to suggest that the minister's reliance on the public interest is misconceived in some way. That falls within the boundaries of these standing orders.
Mr. Speaker, the question was approved for the minister to come and account to the people of Trinidad and Tobago.
Answer that. Leader of Government Business, did you want to make a contribution or shall I go ahead?
Mr. Speaker, you alluded earlier that the provisions of the standing orders clearly allows for the minister to invoke in the interests of the public. So therefore, we stand on that.
For the benefit of the members of the public looking on, so that we don't get carried away with it. Oh, but before I rule on, before the supplemental questions, let me just explore.
But you was supplemental to be asked.
There wasn't a question.
There was a...
All right, let's not let this simple exercise get out of hand. It is a simple exercise, yes, member for St. Anne's East. It is a simple exercise. So this is what, for the benefit of the members of the public looking on, this is what the standing order says. There shall be a 15-minute question period. Then it lists a series of questions. Then it has a G. A minister may decline to answer a question if, in his opinion, the publication of the answer would be contrary to the public interest. Now, the invocation of the public, the inclusion of G, 27G, is a recognition in these standing orders of a concept in law known as public interest immunity. Right? In a court of law, a judge deciding a public interest immunity application has two choices. There are certain set categories, national security being the highest category of public interest immunity exemptions. Where a party, I certainly don't need your interruption either. Where a party in possession of material which the party claims is subject to public interest immunity, and the party invokes the public interest immunity, a judge with inherent jurisdiction to preserve the fairness of a trial may then demand to see the material himself, may then make a decision and say the material is disclosable nevertheless. And then the party seeking to invoke the immunity has a choice. Either you cave in or you invoke or you disclose the material. These standing orders don't permit me as Speaker with any residual discretionary power to challenge, question, or call to account the invocation of the public interest by the minister. The reason for that is very simple. Administrative decision-making is not a binary process. It is not a linear process by which you calculate one line going after the next. It's not a binary process. Administrative decision-making by its very nature is polycentric in nature. So there are many reasons why you draw and you come to a decision. It is not for me to second-guess the minister. I have no such power under these standing orders. So lest that members of the public be misled into thinking that the Speaker of the House has a residual power to demand that the minister answer a question invoking the public interest, no such power exists. So that is my answer.
Introduction of bills. The Administration of Justice Indictable Proceedings Amendment Bill 2025 in the name of the Attorney General.
Honorable Attorney General.
Mr. Speaker, in accordance with Standing Order 64-1B, I beg to move that the next stage of the Administration of Justice Indictable Proceedings Amendment Bill 2025 be taken later in the proceedings.
Honorable members, the question is that the next stage of the Administration of Justice Indictable Proceedings Amendment Bill 2025 be taken later in the proceedings. All in favor say aye. Aye. Those against? The ayes have it.
Public business, government business, bills, second reading.
Honorable Attorney General.
Mr. Speaker, I beg to move that a bill entitled An Act to Amend the Administration of Justice Indictable Proceedings Act 2011, that is to say Act number 20 of 2011, be now read a second time. Mr. Speaker, the Administration of Justice Indictable Proceedings Amendment Bill of 2025, which is before the House this afternoon, is a legislative intervention that we believe to be pragmatic and, given our current challenges, would allow us to provide the police service with easier access to search warrants by enabling justices of the peace to have the jurisdiction which justices of the peace have in virtually every territory that my officers have been able to survey. There are justices of offices of Justices of the Peace in Jamaica, Barbados, St. Vincent, St. Lucia, Guyana, Canada, the United Kingdom, New Zealand, Australia. In all of these territories, Justices of the Peace have a power to issue search warrants in respect of indictable matters. That power was present in this jurisdiction until 2023, when, by way of an amendment to the AJIPA, it was removed. Now, if I can just spend some time on what is AJIPA and why the need for this amendment. It bears repeating, Mr. Speaker, that it was this government that demonstrated foresight and will, and the foresight and will that was necessary to introduce AJIPA in 2011. That legislation represented a paradigm shift in our approach to criminal justice reform. It was a decisive rejection of the archaic system of preliminary inquiries that had for decades served as an impediment to the expeditious administration of justice. Since 2011, Mr. Speaker, there have been 9 subsequent amending acts to the AJIPA of 2011. Upon our return to office, a mere 5 months ago, we sought to engage stakeholders to assess whether the legislation was performing in the way that we first envisaged that it would. Now, it bears repeating that the legislation is under current review, constant review, by a unit in the Office of the Attorney General. So that is the Criminal Justice Unit. One of their main tasks is to keep AJIPA under current review, to look at what is going on and to ensure that the legislation is fit for purpose. Now, we know that there have been wins with the legislation. It has reduced the length of time that it takes for many matters to get to trial. We have taken note of certain high-profile wins. There's the State versus Sheldon Doudnat. That involved charges of kidnapping and motor vehicle theft. The case there was filed in January of 2024. Sufficiency hearing was completed in just 4 months. By July 2024, the accused was tried, convicted, and sentenced. Now, that case clearly illustrates that under the new pretrial procedures, a serious criminal case in the High Court can now be resolved in sometimes as little as 7 months, something that previously could take years under the old system. There's another case, the State versus Ryan Hernandez, in which the indictment was filed in February of 2024, and the sentencing was completed by October of 2024. Now, despite those wins, in some cases, stakeholders have expressed frustrations with certain of the provisions of AJIPA. Among the matters raised are conflicting legislative provisions and the delays occasioned by having matters triable either way before the High Court, get before the High Court only to be sent back to the District Court to be heard. The current state of emergency has seen, Mr. Speaker, a drastic reduction in the incidence of gang-related homicides and other types of violent crime. One of the ways that has been accomplished, the police see, is by what they describe to be proactive policing. Our police officers have conducted thousands of exercises and raids throughout Trinidad and Tobago, have detained a number of persons, some on detention orders and some on warrants, and the effect on the crime statistics has been nothing short of remarkable. But the police service has advised that the limited availability of judicial officers, and in particular masters and registrars, to issue search warrants when time-sensitive investigations demand immediate intervention has significantly hampered policing efforts in some cases. Now, the amendment before us today comes about as a consequence of our desire to consistently keep the law under review. So we have revisited the previous amendment in 2023, which, as I've said before, removed the power to grant search warrants from JPs, placing that power in the hand of judicial officers. And today, we seek to go back to exploring the concurrent jurisdiction for the issuance of search warrants to magistrates, magistracy registrars, clerks of the court, and justices of the peace. Now, what that does is to ensure that law enforcement is not paralyzed by procedural constraints when swift action is imperative. Now, in context, Mr. Speaker, what we are doing is not reinventing the wheel. As I've said, in a number of jurisdictions, the vast majority of jurisdictions, justices of the peace have this power. In 1917, when the Indictable Offenses Preliminary Inquiries Act was enacted, justices of the peace were given concurrent jurisdiction with magistrates to issue summonses, warrants, and other court processes, to grant bail, to fix the amount thereof, to take recognizance, to bind over parties and witnesses, to administer oaths. AJIPA removed several of those functions from the remit of JPs as they relate to indictable matters. Now, the bill itself, of course, treats with indictable matters. The substantive provision is in clause 3 of the bill. There are only 4 clauses in the amending statute. Clause 3 seeks to amend section 10 of AJIPA to empower magistrates, magistracy registrars, clerks of the House, justices of the peace to issue search warrants. Section 10 outlines 6 powers that can be exercised by registrars and masters currently. And those 6 powers include search warrants, but go beyond that so that registrars/masters can also receive complaints on oath pursuant to Section 6 of the Act, issue a summons or an arrest warrant, grant bail in accordance with the Bail Act and fix the amount thereof, take recognizances, and remand the accused in custody. This afternoon, we are concerned with the power in 10.1, which is the power to issue search warrants. And if you turn to 3B of the statute, the amending statute that is before the House, Mr. Speaker, you see that we propose to insert a new section 10.1b, which would allow a magistrate, a magistracy registrar, and clerk of the court, or a justice of the peace, subject to subsection 2, to have and exercise jurisdiction concurrently with masters for the purpose of issuing search warrants. That meets the needs of the police service, it is proportionate, and it is necessary. It is proportionate because it meets the exigencies of the difficulties that we have at this moment in this society. It is not something that is novel. It is used in practically every Commonwealth Caribbean jurisdiction and in the United Kingdom and other Commonwealth territories. Mr. Speaker, Clause 3C has to be amended if we amend 3B to ensure consistency with the amendments and to provide for all judicial officers who possess concurrent jurisdiction with masters, particularly in respect of issuing search warrants and the filing of documents in the High Court, to include the amendment which we make this afternoon. Again, I want to remind this House that we are speaking only of the High Court and that these amendments do not interfere with existing powers in the summary jurisdiction. Finally, Mr. Speaker, the last clause of the bill proposes to amend Schedule 1, Form 1 of the Act by inserting the words magistracy registrar and clerk of the court / justice of the peace. This amendment, Mr. Speaker, similarly seeks to ensure consistency throughout the legislation by listing all persons who are vested with concurrent jurisdiction with masters in relation to the issuance of search warrants. Mr. Speaker, it would be remiss of me if I did not point out that the practice of JPs and certain police officers, perhaps influenced by other persons, that practice has been criticized heavily by the High Court judge in the Brent Thomas matter, which I took pride in bringing an end to ago. In that case, the judge stated, and he stated himself in these words, He says, and I quote, "It is incredibly," those are his words, not mine, "it is incredibly amazing that any justice of the peace in this jurisdiction could have granted a search warrant in terms of the ones that were granted herein, based on the information that they were given as set out above. Clearly, this was a case of mere rubber stamping, and this court will commend this decision to the Justices of the Peace Association in Trinidad and Tobago for its consideration and for such action as is appropriate in the circumstances." Now, he said that that's to be found at paragraph 187 of the judgment of Justice Rampasad. And in 189, he says, "In like manner, all of ASP Birch's search warrants were procured in the same manner without any information sufficient to create any reasonable ground for the Justice of the Peace to suspect that an offense had been, was being, or was about to be committed." Mr. Speaker, I emphasize this case because as we revert to the practice of empowering justices of the peace to exercise a jurisdiction which they've always had in this territory, which they've had up until 2023, which they've had in every territory in the Commonwealth Caribbean, and which they have in practically every territory in the Commonwealth, I have to urge the Justices of the Peace to abide by ordinary principles of equity, there is an ethical code which was in a schedule to one of the pieces of legislation which we was actually before this House but never enacted, and which I've looked at, and it just asks ordinary persons who are justices of the peace to hold the scales of justice evenly between the police officers requesting action and the citizens. Mr. Speaker, with those words, I commend the bill to the House this afternoon. I beg to move.
Honourable members, I shall now propose the question for debate. The question is that a bill entitled An Act to Amend the Administration of Justice Indictable Proceedings Act 2011, Act number 20 of 2011, be now read a second time. Member for Port of Spain South.
Mr. Speaker, the rationale provided by the Honorable Attorney General for this retrograde step is that it's to provide the police service with easier access to search warrants. Yet the Honorable Attorney General had the foresight to know that we on this side would have the dicta of Justice Rampasad in the Brent Thomas case. Because in that case, this was exactly the issue that faced the judge. And the judge found, and I'm paraphrasing, the judge was thunderstruck that a justice of the peace could have acted so shabbily, so without jurisdiction, without rationale, and issue warrants in those circumstances where the judge had to say that that was a rubber stamping and something that ought to be discouraged. That being said, that being the state of play as it relates to justices of the peace and a judicial ruling in a matter that the state has to say that they withdrew, and the Honorable Attorney General took great pride in withdrawing. Good for him. Then, Mr. Speaker, why then put back that power in the hands of justices of the peace in light of that judgment? What has changed? It has been said, another reason was that the police have indicated that they are not getting their warrants as quick as they would want it to be. Where are the statistics? How many cases have been presented to this House to say, well, X amount of cases went to the masters and they were not processed properly because of delay? Or is it the problem was there were leaks in the system in the police and people found out, not the masters, but leaks? Fix the leaks. What we have here, were they giving proper information? But what we have here, Mr. Speaker, is a Napoleonic beat a retreat. They promised us that there'll be no backing down against crime. Yet, first day Independence Parade, everybody hide, they beat a retreat. Now they're retreating, going back to the days of justices of the peace issuing warrant to go and search citizens' houses. But let us look at one item here, which I think will drive home my point. Mr. Speaker, it seems now that a justice of the peace, if you look at clause 1, clause 10, 1b, it allows a justice of the peace to exercise concurrent jurisdiction with masters to issue warrants. So, just as the masters have a jurisdiction to issue a warrant, so now it will be reinstated that the justice of the peace will have that power. So let us see what are the qualifications of a master and that of a justice of the peace. Listen, for the purposes of this debate, there's no derogatory remarks about a justice of the peace. Sometimes when they want bail in a station, a justice of the peace, the right person, they serve a very important purpose in Trinidad and Tobago. But for the purposes of issuing a warrant, there was a reason why that was removed, and I want to go to that. So you have two officers, Master of the High Court and a Justice of the Peace, issuing a warrant. Let's look at their qualifications. Let's do the Masters of the High Court. A Master of the High Court, Mr. Speaker, I don't need an entire 45 minutes, so I will allow whatever. I don't need 45 minutes to respond. The minimum requirements, I promise, I'm not gigging with them, and I'm not. Minimum requirements, LLB and a legal education certificate, admission to practice law in Trinidad and Tobago. A minimum experience of 7 years as an attorney at law, extensive knowledge of the laws of Trinidad and Tobago, extensive knowledge of Workmen Compensation Act, extensive knowledge of the rules and practice of procedure of the Supreme Court of Trinidad and Tobago, extensive knowledge of government procedures and practices, experience in civil and public law procedures, superior communication skills, written and oral, superior mediation and negotiation skills, and most importantly, they are entrenched. The position of their jobs is protected. They fall under the JLSC, and they entrench under the Supreme Court of Judicature Act. Let's then compare, let's do the comparison with the qualifications of a justice of the peace who you are now reverting to give them powers to issue a warrant. A letter applying to become a justice of the peace, a recent resume, 2 references, a copy of national identifications. But what is most troubling, do you know who they have to apply to, which office they have to apply to? To become a Justice of the Peace, you must apply to the office of the Honorable Attorney General. I want to put a marker on that as I continue this submission and this debate. So here we have, Mr. Speaker, one person having the power to issue a warrant. Look at the qualifications. Another group of persons, and all you need is a letter, a resume, 2 references, and 2 forms of national identification. Mr. Speaker, it is chalk and cheese, and it is counterintuitive to put both of them together. But we go one step further. What this amendment seeks to do is to widen and re-widen the scope of persons who were able to issue warrants in respect of indictable offenses. To say that prior to 2023, it was being done by Justice of the Peace in Trinidad and Tobago is just to repeat history and to repeat something, Mr. Speaker, which I say Endell Thomas dealt with. Mr. Speaker, if you remember the case of Endell Thomas, he was a police officer and he was assigned to Tobago, and there was the riots. And he refused to lock up certain persons. And the Service Commission took Endell Thomas and decided that because the law was, the Service Commission felt that they had 7 functions to promote, to transfer, etc. And they thought that they could have disciplined Endell Thomas. And for years, they were disciplining public officers. The Privy Council held that the powers that they thought they had, Mr. Speaker, they didn't have. And they couldn't charge Endell Thomas under the Public Service or the Police Service Act. They had to charge him until the legislation was amended. They had to charge Endell Thomas and those public servants who fell afoul of their duty as defaulters with misconduct contrary to an implied term of your contract of appointment until such time as they amended the law. To say that a Justice of the Peace was issuing warrants up to 2023 is to say nothing. It was wrong then, and it is wrong now. And it is wrong for this reason, Mr. Speaker. When I look at Hines and the Queen, 1977 appeal cases at page 198, but particularly Lord Diplock, what you are doing here, Mr. Speaker, you are giving a layperson the power to issue warrants to send people into persons' homes and suspend, albeit temporarily, their constitutional rights. As what was happening in Hines and the Queen, remember there's the old gun court in Jamaica, and they appointed lay persons who would then try persons who were charged with guns, the same kind of crime that was burgeoning, etc. And this is what Lord Diplock had to say. In the field, he was dealing with punishment. In the field of punishment for criminal offenses, the application of the basic principle of separation of the legislative, executive, and judicial powers that is implicit in the Constitution on the Westminster model makes it necessary to consider how the power to determine the length and character of a sentence which imposes restrictions on the person's liberty of the offender is distributed under these 3 heads. In the exercise of its legislative power, Parliament may, if it thinks fit, prescribe a fixed punishment to be inflicted on all offenders found guilty of a defined offense, as, for example, capital punishment for the crime of murder, or as it may prescribe a range of punishment. What Parliament cannot do, consistent with the separation of powers, is to transfer from the judiciary to any executive body whose members are not appointed under the Civil Service Chapter 7 of the Constitution, a discretion to determine the severity of the punishment to be inflicted upon an individual member of a class of offenders. What we have here is a layperson, if the criteria has been upgraded, what I read, 2 recommendations, an ID card, a resume. They are now going to get back the power to give police officers the power to go into citizens' homes and search the homes, infringing on their constitutional rights. That, Mr. Speaker, is very worrisome. When Section 5 of AJIPA, this so-called very innocuous amendment, is understood, the power to issue search warrants was vested in the masters of the High Court for a particular reason. To understand the gravitas of this power, one must understand Section 5 first. And this is what Section 5 says. Section 5 says that a master has to be satisfied on oath that there is reasonable ground for supporting that there is in any building, aircraft, vessel, vehicle, box, receptacle, computer, electronic device, or place, A, anything upon or in respect of which an indictable offense has been or is suspected to have been committed. B, anything which there is reasonable ground for suspecting will afford evidence as to the commission of an indictable offense. C, anything which there is reasonable ground for suspecting is intended to be used for the purpose of committing any indictable offense against the person. The master, under AJIPA, under the amendment in 2023 by the then PNM government, a very wise and sagacious amendment indeed. The master may at any time issue a warrant under his hand, authorizing any constable or any person accompanying him to search such vessel, device, and to seize it. This warrant may authorize the search of one or more premises specified in the warrant. That is something that was not told to us here. So it's not limited to one premises. It can be several premises. And it also, in our respectful view, it can be attributed to any premises occupied or controlled by a person whose name was specified in the warrant, like you, and you, and you. These are justice of the peace. And also, in certain circumstances, the master may also issue a warrant where it is not practicable to communicate with the owner of the person entitled to grant entry. A search warrant may be issued and executed at any time on any day. So, Mr. Speaker, I want the country to appreciate the extent of these powers, considering that persons have a constitutional right under Section 4A to the enjoyment of their property. We are not saying that there will not be times when a warrant ought to be executed at premises if something untoward and illegal is going on there. What we are saying is that the persons empowered with such a privilege must at least have some judicial training, have some entrenchment in their employment so that they cannot be easily swayed, should not have the spectre of a high court judgment which deals with that sort of issue hanging over that group of persons, and that is exactly what obtains now. This is a fundamental right, the right to the enjoyment of your property, and we sit here very glibly, and everybody sits and we talk about things, but it is real. The enjoyment of your property is a fundamental right which protects every citizen against deprivation and ensures that there are fair procedures when your proprietal rights are being affected. Persons in Trinidad and Tobago, Mr. Speaker, have a constitutional right not just to own, but when you own it, you must enjoy it without unreasonable interference from the state or anybody whatsoever. When you look at the powers of the master as it currently stands without the amendment, the master has a significant amount of power. But concomitantly, the master has a significant amount of experience, a significant amount of training, a significant amount of a track record. And to say, Mr. Speaker, that there aren't sufficiency of masters, you could have said that maybe about 2-3 years ago, when there were only 2 criminal masters. There are now 11 or maybe 12 criminal masters. So there is no issue of a dearth of masters. There are at least 11 of them in Trinidad and Tobago. Where are the statistics? Where are the instances where the masters have proven to be insufficient or tardy in issuing these warrants? Or is it simply the police would like easier access without the scrutiny of a judicial officer properly trained to ensure that warrants, as was done in the Brent Thomas case, according to the High Court judge, are not issued without proper oversight? When you look at the powers of the masters, and you understand its breadth and the length of it, you can say, Mr. Speaker, that they can tailor the warrants, and the scope of the intrusion that exists now is not limited. It's a wide scope, as I have indicated in A, B, and C. Furthermore, all that is required is reasonable ground for suspecting. That's a very wide test, you know, Mr. Speaker. That is why a judicial officer and a judicial mind is supposed to implement and to do that litmus test. Reasonable ground for suspecting. That is why, Mr. Speaker, you ought not to discuss law with lay persons, because they will never understand Wilmington and the DPP. They will never understand mens rea and actus reas. If you shoot the man, you shoot the man, not knowing well you have to have the intention. So, Mr. Speaker, it is in this context of the constitutional right to the enjoyment of property that we on this side say that this bill is severable, because it can stand if you sever the inclusion of justices of the peace. And if that is severed, we support this bill wholeheartedly, because it seems to be going in a direction where you're expanding the powers of judicial officers, persons trained in the discipline of the law, to issue warrants to police officers, and not warrants issued under the dark of night in a rum shop. Mr. Speaker, do you recall there was a case that was dealt with, I think it was in October 2014, by then senior magistrate in the San Fernando First Court. Senior magistrate, I think, is Lucina Cardenas Ragunanan, where there were 3 police officers charged, and the magistrate had to question the circumstances and the manner in which the justice of the peace handled bail for those officers in serious charges. That is because, Mr. Speaker, they were not trained legally. And that is the juridical objection to the inclusion of the justices of the peace. If you leave the others, if you leave, for example, Mr. Speaker, the magistrate the magistracy registrar, or clerk of the court, it gives the masters more help. So if you go back to the theory, the main thesis of the Honorable Attorney General, that they're not getting the masters, not moving quickly enough, maybe they're overwhelmed. Well, you now have with this amendment, the magistracy registrar, and the clerk of the court, and the magistrate. Why the justice of the peace? All of these three groups of individuals are legally trained. Or is it that they need all four? Why do you need a justice of the peace in these circumstances? I would hope that in reply, we get an answer that makes sense, because I have not heard one iota of evidence to say that, listen, this is the problem that existed, and these are the statistics that support the problem. In other words, is it that if it's numerical, wouldn't these three bodies now fill up the numbers, Mr. Speaker? Now, this amendment, as it seeks to give the concurrent jurisdiction to the justice of the peace, we say, if that is excised on this side, we will support this piece of legislation. The reason why masters and only masters were given the power initially is because there was a recognition in 2023 that this power to issue a warrant to search people's premises, to temporarily suspend their rights in the traditional castle principle sense, Mr. Speaker, it requires judicial oversight, given its impact, given its purport. The judicial oversight ensures that searches are not arbitrary, they are not overly broad, and in allowing the police to do their jobs, it balances, it is proportionate by protecting individual rights to property. That is proportionate. And if it's a question of numbers, meaning there's an overwhelming request, then the magistrates can fill up the gap, the magistracy registrar can fill up the gap, and the clerk of the court can fill the gap. During a search, Mr. Speaker, the rights of the owner to exclusive possession, privacy, and quiet enjoyment is suspended during the tenure of that search, That's the practical aspect of it, You own the property, but once they come with a warrant, for the time that they're there, your property belongs to them to do what they may for their investigations. That is why it is important to have judicial oversight. And to say you're going back to what existed in 2020, before 2023, does not deal with this problem. And, Mr. Speaker, I will also say that masters, by virtue of their office as a neutral judicial authority to determine if there is a reasonable ground for suspecting, and the judicial officers are the perfect group of individuals to put those powers in their capable hands. The judicial officers are deemed to be neutral and important, most importantly, independent, to ensure fairness and to act as a safeguard against government overreach. Mr. Speaker, my disquiet comes from a government who, from one of their very first acts in this parliament, say what they want, brought ad hominem legislation to this parliament, Trinidad and Tobago, there is a concern, whether you're old or young, of what can happen, in this country, they can do that with such impunity and everybody glib before the scrutiny of Parliament, what happens outside of the scrutiny of the masters when they want a warrant to go after someone in the same ad hominem manner? What happens? And what is important, Mr. Speaker? Mr. Speaker, in preparation for this, I remember that before 1990, you couldn't refer to the Hansard until the House of Lords did Pepper and Heart. But particularly, Mr. Speaker, I was preparing this debate and I was examining the speeches of the lower lords, and particularly I think is Lord Bridge of Harwich. Please forgive me if my pronunciation is not to your standard, Mr. Speaker, but I from Port of Spain South. Forgive me. But here's what it had to say. She sounds more like you. Mr. Speaker, I'm sorry. She sounds more like you. Now, Mr. Speaker, here's what they had to say. They said now, in the Parliament, it is now necessary that material relied upon consisted of one or more statements by a minister or other promoter of the bill, together with such other parliamentary material as was necessary to understand such statements and their effect. I say that because I see a concentration of power, and I will, Mr. Speaker, I went actually to the speech of Lord Bridge, and that is at page 617, letter B of the judgment. And here's what he had to say about this. It should, in my opinion, only be in rare cases where the very issue of interpretation which the courts are called on to resolve has been addressed in the parliamentary debate, and where the promoter of the legislation has made a clear statement directed to that very issue. That case, that reference to Hansard, is likely to be of any assistance to the courts. In this Parliament, on various pieces of legislation, there have been pronouncements. And we on this side, we are not sleeping. We have marked the pronouncements. We have marked what has transpired here. We have marked Pepper and Heart. Because we say that in this Parliament, Mr. Speaker, we have a duty to defend the people of Trinidad and Tobago from any tyranny which may appear. Let me start now to connect the dots.
Mr. Speaker, 48-1.
No, I will allow him to continue, but your time is up. You did promise you were not going to use your 45 minutes.
I will not use my 45 minutes.
It appears that you are borderline reneging.
Can I ask for my extended
yes, you
time?
Can.
Thank
With
you,
the
Mr.
express
Speaker.
disclaimer that you are not going to use.
And before, thank you, Mr. Speaker. Mr. Speaker, we say that a judicial officer, such as a master or even a magistrate, they are entrenched. Can we say for certainty that a justice of the peace who is not a judicial officer can be sufficiently out of the reach of the talons of any government? Can we say that a justice of the peace has the same level of independence? Can we say that a justice of the peace has the same level of judicial training, judicial foresight, prudence, experience to ensure that applications for warrants, as was in the Brent Thomas case, was not misused? I want to give some context, and I just want to state the facts of the circumstantial evidence without making any conclusion, without forming any conclusion. If you recall, on the 28th of April, one chapter was closed, and effective 9th of May, Arthur Barrington, time as director of the SSA, it was revoked on the advice from cabinet.
48-1.
Relevancy of that, unless you could tie it to the search warrant.
Yes,
Hang on a second, will you?
Yes, Mr. Speaker.
The point you are making is that the legislation as constructed by the inclusion of justices of the peace do not render them independent or immune from interference. I would be very grateful if you could if you could confine your comments to that narrow confine which you expressly identified. And just for the clarity and accuracy of the public record, can I just make an inquiry of you? Is the clerk of the court referred to in this legislation a judicially trained officer as well? So that for the clarity and accuracy of the public record.
The clerk of the?
Clerk of the court.
Yes.
Is a judicial officer?
Mr. Speaker, I didn't understand the clerk of the court to be the clerk of the peace.
Oh, well, my misunderstanding.
Clerk of court different from clerk of peace. Yes,
right,
Mr. Speaker.
So the clerk of the court, for the accuracy of the public record, is a defined officer with qualifications and so on?
That is my understanding, okay, as opposed to the clerk of the peace.
I just want to ensure for the clarity and accuracy of the public record.
Mr. Speaker, I understand what's happening here, so I want to be clear. So let me make it pellucidly clear my point. My understanding is that there is a difference between the clerk of the court and the clerk of the peace. But as you know, Mr. Speaker, I left no stone unturned. Just for the record, if it is the old clerk of the peace, then, Mr. Speaker, they do not have the training of... No.
Accuracy of the public record.
In fact, Mr. Speaker, what they have is, for under training, expertise and training, considerable experience in general office work, filing, training as evidenced by a referral and a certificate, and I think there's a level there, and a combination of experience and training. So, Mr. Speaker, if it is that it turns out that the clerk of the court is the equivalent to the clerk of the peace, then our objection would stand a fortiori. But I understood that there was a distinction between clerk of the house and clerk of the peace. But I did my research in any event. Therefore, as I continue, Mr. Speaker, when you have we understand the need to meet the crisis of crime head on, and we agree. We understand the seriousness of the threat, and we say we would like to be part of an organized, structured approach and persons all operating above the law. It does not mean, Mr. Speaker, that we would agree to legislation that brings to laypersons powers that they ought not to have had and the training that they do not possess. Don't be fooled into thinking that there's a minor, inconsequential amendment. I have explained the reach of the warrants and its impact on the citizens' constitutional rights and the enjoyment of their property. And by property, it also means your electronic devices. Justice of the peace, they have an important role to play in Trinidad and Tobago, and I agree. But as it relates to warrants, has there been, for example, the Honorable Attorney General in his contribution asked that Justice of the Peace act in accordance with good conscience, etc. Have there been any disclosure if their training and skills have been updated in order now to receive, again, this wide power? Has it been disclosed how well informed they have been? Have it been disclosed if they have been placed on any refresher courses? A JIPA intentionally removed the jurisdiction of magistrates and justice of the peace as it relates to the initiation of indictable matters. Indictable matters are no longer within the purview of the summary courts. We make a step backward in improving judicial oversight when we now seek to place again the powers to issue warrants to go into persons' homes, to go into persons' devices, their electronic and otherwise devices, their cars. We need to question, what is the rationale? What is the rationale for this sudden change? And that has not been, in my humble view, Mr. Speaker, adequately answered by the submissions and by the pleadings made by the Honorable Attorney General and the reasons that were outlined by him when he presented this bill. What does procedural constraints mean? Does procedural constraints mean that a master, in taking his or her time to look at whether there's reasonable cause, is a procedural constraint, or is that a procedural safeguard? Mr. Speaker, all we can do on this side is to lay down our marker, do our duty to the best of our ability, and we are disquieted by this so-called simple, innocuous, but we say pernicious amendment. Thank you, Mr. Speaker. I have not taken my full word.
Barataria Sanwan.
Thank you very much. Thank you very much, Mr. Speaker.
Bring some clarity.
To join this debate on the Administration of Justice Indictable Proceedings Amendment Bill 2025. And Mr. Speaker, I sat here and I had to listen to my colleague from Port of Spain South. And I wondered a couple months ago if he would have had the same view. Because you see, Mr. Speaker, when they're in opposition, they say a different thing compared to when they're in government. But this government, Mr. Speaker, will call them out on their hypocrisy. We will. All of a sudden, Mr. Speaker, they discover these buzzwords like training and judicial oversight. Fairness, democracy. Mr. Speaker, they knew nothing of that a few months ago. They knew nothing of that a few months ago. And then the member says, and I think the Attorney General was very pellucid when he piloted the bill by saying, there are challenges with respect to the expediency and the timeliness for police officers to get these warrants. Hence, we are introducing this amendment. And my colleague from Port of Spain South says, well, what is wrong with the masters taking time to look at the case? You know what is wrong with that, Mr. Speaker? Because the criminals are running amok in Trinidad and Tobago. We are standing on the side of law enforcement to get the criminals behind bars.
But, Mr. Speaker, every time we bring a bill here to fight crime, they are the bar to us passing the bill. Mr. Speaker, all of a sudden, they're talking about judicial oversight and that we shouldn't give JPs this power, but I will address that soon, because my friend, being a very senior criminal practitioner, should know better. He should know better. But I want to tell him and caution the opposition, Mr. Speaker, in colloquial terms, hush your mouth when it comes to Brent Thomas. Because we don't want to know about the JPs in Brent Thomas, you know. We want to know who is the minister that authorized the police officer to jump on a plane, go to Barbados and kidnap one of our citizens, abduct them and bring them back to Trinidad and Tobago without proper judicial oversight. Don't tell us about JP. Tell me who was the former minister who did that. So hush your mouth when it comes to Brent Thomas. And my friend, Mr. Speaker, is absolutely...
48-4, please. That seems unparliamentary to me.
Member. Okay. Okay, let's rephrase it.
Mr. Speaker, I move on. I think that's it. I wouldn't comment from my friend on San Fernando East. I don't know if he understands what we're doing here today. But, Mr. Speaker, I want to get back to the meat of the bill and some of the points that Port of Spain South have raised. Mr. Speaker, you see, when you heard, or the members of the public listening to Port of Spain South, you would have thought that this JIPA bill would have prevented a JP from granting all warrants when it comes to offenses. But we have to educate the population. There are two types of criminal offenses, or three. You have summary offenses, you have indictable offenses, and you have triable either-way offenses. When a JIPA was introduced, it was only to prevent a JP from granting a search warrant for indictable offenses. It did not interfere with the JP's jurisdiction under the Summary Courts Act to issue warrants for summary offenses. So all this fear-mongering, Mr. Speaker, a JP in this country can issue a search warrant for a summary offense. For a summary offense. If the policy of the then government was that remove all of this judicial power from the JP, why they didn't do it for JPs for summary offenses? Why? Is a problem now? Is a problem because you sit down on that side of the chamber now? Mr. Speaker, so that shows that my friend had a complete misunderstanding of the exercise today. Complete misunderstanding. And this is not no grand judicial power that we are granting to the JP, Mr. Speaker. If you read the legislation, and I can point my colleagues opposite to the section of the law that deals with these search warrants, Mr. Speaker, it's at section 5. There's a law test. The judicial officer in the case of the JP or the magistrate registrar must be satisfied by proof on oath that there is reasonable grounds for suspecting the indictable offense, Mr. Speaker, under various circumstances. So it's a very low threshold, and there are many cases that outline the low threshold. So what is wrong with what we are doing here, Mr. Speaker? What we are doing is giving law enforcement that power, that expediency, together with judicial oversight, to go after the criminals. To go after the criminals. So it's a very low test. And my friend cannot compare what a master, the magistracy registrars, and a JP does. It's three totally different things. Because I saw he tried to conflate the issue by talking about the qualifications of a justice of the peace as compared to that of a master, as compared to that of a magistrate registrar. It is comparing apples and oranges, Mr. Speaker. You cannot put the both under the same equation. They perform various functions, different functions. And we're not saying that the JP is giving all its judicial power to grant bail and so on. This bill seeks to directly one point which is dealing with the issue of the issuance of a search warrant. That's all. That is all. But then I heard my friend jump up and said, and he said it very sneakily, Mr. Speaker, he said, the Castle principle. Well, I rock back on my seat, Mr. Speaker. The Castle principle. They are invoking the Castle principle when it comes to this particular bill, Mr. Speaker, and the protection of your home and your rights to property and so on. But when we have stand your ground consultation going on, no, that is a bad thing. There's no Castle principle, Mr. Speaker. This Castle thing is a bad thing when it comes to stand your ground, but when we are taking matters in our hands to fight the criminals, they are invoking the Castle principle, Mr. Speaker. You see the level of hypocrisy that we are getting from the opposition. And we will identify it and call them out at every stage, Mr. Speaker. We will do it. We will do it. And you see, it's very difficult to take any sort of legal advice from my friends opposite. It's very difficult. And I'll tell you why, Mr. Speaker. My friend stood up confidently, said, the Attorney General appoints justices of the peace in Trinidad and Tobago. Well, I say he fired me. Mr. Speaker, my friend did not read the Gazette because the responsibility of justice of the peace now falls under the Ministry of Land and Legal Affairs. But I wish to go one step further. As Minister, I don't appoint the justices of the peace. According to the Summary Courts Act, it is the President that appoints the justices of the peace after a very significant vetting process and application that is done through formally the Office of the Attorney General, goes to the Office of the Solicitor General, background checks are done with the police service. There's a rigorous process, Mr. Speaker. I admit there may be issues with qualification and so on, and I'll address that a little later on when I come into various other matters in the debate, Mr. Speaker. So, Mr. Speaker, I then heard about quotations from Endell Thomas and Hines against the Queen in terms of the separation of powers principle. Where was Endell Thomas when they were fighting the revenue authority? They were prosecuting the revenue authority matter. Where was Hines against the Queen when they abducted Brent Thomas, Mr. Speaker? Mr. Speaker, you see, that is a total misapplication of the law. It clearly does not apply in these circumstances of this bill, Mr. Speaker. It clearly does not apply. I think my friend was quoting these cases to say that he went to law school or something. But, Mr. Speaker, it has nothing to do with the principles in this bill. This bill is a simple bill where we are giving a certain category of officers the power to issue a search warrant, Mr. Speaker. Very, very simple piece of legislation that we're dealing here. So what is so innocuous about this? What is so innocuous? Do they have something to hide? Do they have something to hide, Mr. Speaker? I'm asking. Because I hope not, Mr. Speaker. And you see, there's another issue with respect to what the opposition is raising. And it deals with, and I'll get into that now, Mr. Speaker, with respect to the applications, the qualifications of persons who are interested to be justices of the peace. Mr. Speaker, they sat for the last 10 years, Mr. Speaker, and did nothing, absolutely nothing, to reform these officers called justices of the peace, Mr. Speaker. Mr. Speaker, as Minister of Legal Affairs, when I went into that ministry, Mr. Speaker, one of the first things that we have done in government, Mr. Speaker, is on the 5th of August 2025, I took a note to Cabinet for the establishment of an interministerial committee to conduct a review of the systems, processes, and governing framework for the appointment of commissioners of affidavit, justices of the peace, and marriage officers, Mr. Speaker. This is a government working, Mr. Speaker. Just a few weeks shy of government, Mr. Speaker, we have identified this issue with respect to the justices of the peace and the qualifications and so on, and the work has already started. The committee has met, Mr. Speaker, and I can tell you, this is not a small committee. This committee involves the Ministry of Legal Affairs, the Ministry of Homeland Security, the Trinidad and Tobago Police Service, the Ministry of Public Administration and Artificial Intelligence, the Ministry of Culture and Community Development, the Justice of the Peace Association of Trinidad and Tobago, the Office of the Prime Minister, the Department of Criminal Law, the Department of Civil Law, the Law Reform Commission, and the Tobago House of Assembly. Mr. Speaker, we are serious about getting the people's business done. We are serious. We are serious. And Mr. Speaker, this particular committee identified some issues with respect to the justices of the peace. Everyone knows that we have identified it's a long-standing issue that every government has faced, Mr. Speaker, but we are actually the ones that are addressing this particular issue. It deals with various issues that we have identified. For example, the modernizing the appointment process in keeping with leading practices in the Commonwealth, the minimum qualifications, age requirements, and tenure of office, the governance review, code of ethics, and the establishment of a disciplinary body. And those are some of the matters that my colleague, the Minister of Justice, had raised with me. The continuous upskilling of licensed justices of the peace for proper administration of justice. The scope of ex officio JPs, because you have JPs that are also ex officio by nature of the office that they hold, Mr. Speaker. You have legislative review, updating the fee structure, the honorarium. Do you know, Mr. Speaker, that currently JPs are given an honorarium of $3,000 every quarter, and they don't get that automatically. There's a level of manual submissions of documents and so on before they are actually paid this honorarium, and they conduct public business. The digitization opportunities, the public-facing registry of active justices of the peace. Would you believe when I went into that office, Mr. Speaker, it was a total mess. They left it in a total mess. I asked, as soon as I became Minister of Legal Affairs, for a brief for documents relating to justices of the peace. I want to see the public register of all of who are justices of the peace in Trinidad and Tobago. Mr. Speaker, you know that they could not tell me that there's a public register. We are starting from ground zero with this project. Do you know what that government was doing, Mr. Speaker? They had a single AO2 officer in the office of the Solicitor General treating with every single JP application in this country. An AO2 officer. An AO2 officer, Mr. Speaker. When I went in there were boxes of files and old files and cabinets with applications. And then when I went there, the officer was not there, so I did not get to meet the officer, Mr. Speaker. But then I asked, well, give me a registry of all these files. Mr. Speaker, there is not even a registry of the files. We had to dig through boxes and boxes of documents, and so we were able to then identify that there were 100 pending applications from 2019 to 2024. They did not appoint any JPs, Mr. Speaker, within that period. So I don't know what they were doing, Mr. Speaker. They were passing bad law, and they couldn't appoint a JP. That was one of the worst governments that this country has ever faced, Mr. Speaker. Mr. Speaker, I can tell you some of the plans that we have. Some of the plans include creating a simple document such as a public register so members of the public can go onto a public website and they can see all of the justices of the peace. Do you know that in Jamaica, you can identify each JP based on the parish in Jamaica? We are one of the most developed country in the Caribbean, and we don't even have these public registers available, Mr. Speaker. What were they doing? What were they doing? Absolutely nothing, Mr. Speaker. They were doing absolutely nothing. So, Mr. Speaker, I can tell you, as the Minister of Land and Legal Affairs under the leadership of the Honourable Member for Superior, Prime Minister of Trinidad and Tobago, we will ensure that we get this work done, and we will appoint justices of the peace in accordance with the law, Mr. Speaker. We will do it. We will not have these applications piling up, getting cobweb. When I asked, well, how long it will take to appoint a justice of the peace in this country, they told me 5 years. I said, but why? Why 5 years? I could not get an explanation, Mr. Speaker. I couldn't. I couldn't. They had about 2 or 3 ministers sitting in the office of the Attorney General last time, one always shouting down the place in St. Augustine, Mr. Speaker, doing absolutely nothing. I think she was a contender for my friend from St. Augustine, Mr. Speaker, and did absolutely nothing. She did absolutely nothing, Mr. Speaker. And you had all of them in the Ministry of the Office of the Attorney General and Ministry of Legal Affairs, Mr. Speaker, and you had all of these pending applications inside it, and they couldn't do a single thing about it. In a few weeks, Mr. Speaker, we have already started the work. We have already started the work. And there is, for example, other matters that we have identified, Mr. Speaker, when it comes to justices of the peace and so on. And I want to also look at other jurisdictions, what they have done, and what we are looking also, Mr. Speaker. So, for example, there was a comparative analysis done with respect to the United Kingdom, Canada, Australia, New Zealand, Barbados, Jamaica, and Trinidad and Tobago. All of those jurisdictions, except Trinidad and Tobago, have standalone legislation that deals with justices of the peace. So in the UK, you have the Courts Act of 2003. Canada, you have the Provincial Law Act. In Australia, you have the State JPs Act. And in New Zealand, the Justices of the Peace Act 1957. In Barbados, there's a Justice of the Peace Act. In Jamaica, there's also a Justices of the Peace Act. And we looked, Mr. Speaker, at various ways in which they fall under that structure. You have the appointment process and the criteria for approval, the approving authority, you have the term of appointment and renewal provisions, the fee or revenue model, the use of technology and digitization, the accessibility for underserved communities, and you also have oversight and accountability. And Mr. Speaker, there's an issue that was raised by the association, the Justices of the Peace Association, and members of the public service, in that justices of the peace are appointed based on a district. And the districts are county councils. You have St. Patrick, you have Carney, and so on, Mr. Speaker. But when we had passed the District Court Act and so on, the districts in Trinidad and Tobago were now divided based on North, South, and Tobago. But yet the justices of the peace, their jurisdiction is limited geographically. And when you look at that, Mr. Speaker, you could also have an issue of areas where JPs may benefit more as compared to other areas. For example, where there are areas where prisons are located, those geographical spaces. So we have to now look at whether or not we remove this bar for JPs to be within a particular jurisdiction, or they are allowed to function nationwide, Mr. Speaker. And that is something that is under active consideration. Something as simple as that the other, or the former government couldn't even think of, Mr. Speaker. They couldn't think of that. Because there's a level of laziness on that side, Mr. Speaker. And Mr. Speaker, we understand. We are going to give up power. That existed before to the JPs, so it's not a new power. It's something that was suspended really in a very short space of time when a JIPA was in fact proclaimed. And Mr. Speaker, what we also have to consider is code of ethics, because we have to regulate the JPs now. You also have to consider whether or not there's a disciplinary proceedings or grievances and so on. But it doesn't mean, Mr. Speaker, that if something goes wrong because a JP may have exercised his powers wrong, or that he exercises power incorrectly or lawfully, Mr. Speaker, like any other judicial authority, that is why you have areas of appeals and so on, or review in certain circumstances. Mr. Speaker, we have had many cases in this country where someone is open to filing a claim against the state to review whether or not a particular procedure or something was applied correctly, and that person can have a level of redress to the court. So nothing in this bill, Mr. Speaker, prevents a member of the public who may believe his rights may have been infringed, Mr. Speaker, from access to the court. So nothing prevents that, because a member of the public still has access to the court, Mr. Speaker. They still have that level of access to the court. There are other matters with respect to the Justices of the Peace, Mr. Speaker, there is in fact a Law Reform Commission report, a paper, and I want to commend some of the members of the Law Reform for preparing this, Mr. Speaker. And I want to give you an outlook of what it looks like with respect to the JPs that are appointed in Trinidad and Tobago. Because the current statistics which were received, and this is the most updated so far, is from 2020, Mr. Speaker. And the current statistics at the ministry indicate that there are about 126 JPs in the country. And how we were able to gauge this is because of the honorariums. You have to measure how many honorariums you pay, so therefore you know how many JPs we have. Island-wide, we have 11 JPs. In Arima, we have 2. St. George West, 12. St. George East, 11. Caroni, there are 9. Couva, there are 18. Victoria is actually one of the largest districts that we have. They have 3. Victoria West, 26. Victoria East, 2. St. Patrick East, 10. St. Patrick West, 4. Northeastern counties, 3. Southeastern countries, 6. Tobago, 9, Mr. Speaker. And that is what we have dealt with so far. For the period 2015 to February 2020, there were several applications and so on that were received by the Office of the Attorney General, at that time having ministerial responsibility for it, Mr. Speaker. And Mr. Speaker, we understand that when we went in there, we met a historic, archaic system where if someone is interested in being a Justice of the Peace, you know what they do? They write a letter to the minister expressing an interest with recommendations and so on. We are in the year 2025. That is something, Mr. Speaker, we intend to digitize so that you have a digital application where someone who wants to be a JP or so on can file it digitally. We have a proper form, prescribed forms and so on, so therefore you have all of the information readily available so we can process these applications in a very timely manner and ensure all of the due diligence is done. Mr. Speaker, there's also issues, as I mentioned recently, with respect to whether or not there should be disciplinary committees and so on set up to deal with these JPs. Also, training is one of the matters that we are looking at in terms of training. However, JOPAT, which is the Justice of the Peace Association, they undertake various training courses and so on between their membership. One of the other issues that have been identified is qualifications, as I said before, and tenure and renewals of the person's licenses and so on. Age limits, those are all matters that have been addressed. Stipends, the handbooks and the code of ethics. And Mr. Speaker, every step of the way in terms of getting this system reformed, we intend to have that level of stakeholder consultation because we understand the important duty that these Justices of the Peace perform in Trinidad and Tobago. And now with respect to granting them this additional power through this particular bill, Mr. Speaker, we understand that we are also going to have that level of consultation when it comes to any reform that we have. And Mr. Speaker, I can tell you, and I'm going to speak to the Attorney General very shortly on this matter, Mr. Speaker, that we intend to also have legislative changes when it comes to Justices of the Peace, because right now we rely on a particular section of the Summary Courts Act which deals with just the appointment of the JPs in Trinidad and Tobago. So all of these matters that I have outlined, I don't want my friends opposite to be troubled. We understand the mess that you have put us in. We understand what you left us with. The difference is, Mr. Speaker, we will fix it. So all of the fears my friend from Port of Spain South raised, Mr. Speaker, is what we inherited because of them. Because of them, Mr. Speaker. But we intend to make the changes. We hear what the members opposite are saying, Mr. Speaker, but unlike them, we are not tone deaf. We listen, we lead, Mr. Speaker. We have a Prime Minister who listens and who consults, Mr. Speaker. And she is not afraid, Mr. Speaker. So, with these very few words, Mr. Speaker, I want to support this legislation that has been brought by the Attorney General before this House, Mr. Speaker. And I commend it to the House, and I ask all here who are right-thinking citizens and who want to join us with the fight against criminals to place their support behind this particular piece of legislation, Mr. Speaker, as we go forward. And I thank you very much.
Member for Laventille West.
Mr. Speaker, I thank you for the opportunity to contribute to this important debate. And in my preparation for today's debate, please, Mr. Speaker, I often remind myself of my solemn duty, first as a citizen of this republic, second as a parliamentarian and representative for the resilient people of Laventille West, and thirdly, as an officer of the court and a practicing attorney at law. Mr. Speaker, as I enter the hollow halls today with the aim of debating and shaping the laws of our country, I am duty-bound to hold justice and fairness as my compass. In a balanced exercise as parliamentarians, Mr. Speaker, we must endeavor to ensure the rights of each citizen of this country, most importantly, the law-abiding citizens of this country, and compare and balance that, Mr. Speaker, with the safety, security, and protection of our citizens and the greater good of our country. The bill before us today, entitled the Administration of Justice Indictable Proceedings Amendment Bill 2025, seeks to amend the Parent Act, called the short-term JIPA, which was proclaimed after its final amendments in 2023, Mr. Speaker, December of 2023. Mr. Speaker, in my private practice, almost every day I'm before a master, magistrate, and or judge, seeing firsthand the implementation and the effects of a JIPA. A JIPA is indeed good law, Mr. Speaker. Whilst first passed in 2011 and piloted by the then Minister of Justice, the late Herbert Vonley, their version of a JIPA, Mr. Speaker, saw the ugly head of Section 34. Planting a stain on this honourable House.
Mr. Speaker, 48.1, this bill deals with the amendment to Section 10 of the law, Mr. Speaker.
Member, I think the member for Barataria is correct. I don't think there's any Section 34 on the old versions of a JIPA and all of that and the early proclamation really has nothing to do with this minor amendment that is before the House today. It really doesn't have anything to do with that. It really offends the relevance principle.
Mr. Speaker, I'm grateful for your guidance. But I would just say it's on the basis of the historical context that the Honourable Attorney General laid out before going through this bill, in which but I am guided. Mr. Speaker, I seek your protection from the member for Toko Sangani, please. Shouting and screaming.
All right. Can we take down the shouting a notch, please? This is a simple four-provision bill. It really is a bill which seeks to amend very sterile provisions of a Parent Act. So let's continue.
Mr. Speaker. Thank you very kindly, Mr. Speaker. Mr. Speaker, the PLM not only supports good legislation, and this opposition not only supports good legislation, but we amend and implement better legislation. So please permit me, Mr. Speaker, to commend the former Attorney General, Mr. Faris Alwari, as well as Mr. Reginald Amor SC, for their foresight in refining, amending, and implementing the parent law of a JIPA, please, Mr. Speaker. Mr. Speaker, what we are witnessing since the implementation of a JIPA is a significant improvement in the compliance from prosecution and defense and the efficiency of the criminal justice system, Mr. Speaker. And therefore, we have seen, even in the recent statements addressed by the Honourable Chief Justice, that the judiciary is confirming that AJIPA is in fact working, but it's not perfect. So there will be times where we have to look at the current act, see how we can improve the shortfalls in the instances, and before coming to the Parliament, get the relevant stakeholders involved, the Law Association, the Judiciary, the TTPS, the Office of the DPP, to give their opinions in how to better shape this law, the AJIPA and other laws, please, Mr. Speaker. Mr. Speaker, I would admit that in conversations with several members of the Trinidad and Tobago Police Service, I understand the challenges for obtaining search warrants in a speedy and reasonable time frame since the passing of AJIPA. Mr. Speaker, when AJIPA was proclaimed in December 2023, we had an average of about 2 to 3 masters. And therefore, when police officers want to get a warrant for whether it is an indictable matter or a matter that is triable, either way, they will have to make their application on oath, file it in the High Court, and that sometimes takes days, and in some instances, especially at the start of the proclamation of AJIPA, would sometimes take weeks before a police officer can obtain a search warrant. That is unreasonable, Mr. Speaker. And therefore, over the last 2 years, we have seen an increase in the resources given by the then PNM administration to the judiciary to ensure that we hire more masters and hire more judicial support officers so that we can have much more efficient management of these issues, Mr. Speaker. So, AJIPA is a work in progress. And, Mr. Speaker, as it relates to Section 5 of AJIPA, it requires, and that is not in terms of the amendment, but Section 5 works hand in hand with Section 10 and affects Section 10 of AJIPA, which is being sought to be amended. So Section 5(1) of AJIPA, as amended in 2023, states as follows, Mr. Speaker. A master who is satisfied by proof on oath that there is reasonable grounds for suspecting that there is in any building, aircraft, vessel, vehicle, box, computer, electronic device, or place, A, anything upon or in respect of which any indictable offense has been or is suspected to have been committed, B, anything which is reasonable grounds for suspecting will afford evidence as to the commission of an indictable offense, or C, anything which there is reasonable grounds for suspecting is intended to be used for the purpose of committing any indictable offense against the person. May, and this is the discretionary aspect, please, Mr. Speaker, may at any time issue a warrant under his hand authorizing any constable or any person accompanying him to search the buildings, homes, etc., or devices for such thing and to seize it and report the seizure to the master issuing the warrant or another master in accordance with subsection 3, Mr. Speaker. Mr. Speaker, it is not by VAPs that the lawmakers of this very same House would have decided to strip the justices of the peace and to a lesser extent magistrates of this very serious and critical judicial function, please, Mr. Speaker. The bill brought today by the Honourable Attorney General seeks to once again take this country down a very dangerous road. A dangerous road where there is considerably greater potential, Mr. Speaker, for the arbitrary use and abuse by the police in obtaining search warrants for indictable offences and triable by either way offences to enter citizens' home by way of simply rubber stamping approval by many justices of the peace. And it's clear that the indication by my friend from Bataya San Juan in terms of the recent Brent Thomas case and the Justice Devendra Rampersad's statements concerning the JP's rubber stamping of warrants. So it is clear that there is a practice in Trinidad and Tobago developed over the years that is a bit dangerous, Mr. Speaker. Mr. Speaker, paragraphs B and C of the clause 3 of this bill seeks to give magistrates, magistrate registrars, clerks of the courts, and justices of the peace concurrent jurisdiction with masters to issue search warrants for indictable offences and matters that are triable either way. Mr. Speaker, in considering granting and or issuing a search warrant of this nature, it seeks, Mr. Speaker, to put a judicial officer, and now the government is proposing other class of persons, to consider some balancing act. On one hand, the judicial officer must appropriately balance the enshrined rights of the citizen as guaranteed in Section 4 and 5 of the Constitution, but more specifically as it relates to Section 4A and C of the Constitution, which is the right of the individual to life, liberty, security of the person, and enjoyment of property, and the right not to be deprived thereof except by due process of law. And C, Mr. Speaker, the right of the individual to respect for his private and family life. On the other hand, Mr. Speaker, the court or the judicial officer often have to consider the safety, the security, and the protection of the society at large, and what is in the interest of justice in terms of preventing certain crimes, and of course, getting certain evidence, guns off the street, drugs off the streets, etc., Mr. Speaker. This is a serious responsibility, Mr. Speaker. It is one, Mr. Speaker, that we have absolute no objections to masters administering that discretion, magistrates administering that discretion, magistrate registrars administering that discretion, as well as clerks of the court, Mr. Speaker. But we have serious difficulty in accepting that justices of the peace are going to be made once again to approve and issue these search warrants for such serious offenses, Mr. Speaker. Because, Mr. Speaker, as my friend from Port of Spain South would have indicated, the difference between the qualifications to be a master, a magistrate, a registrar, Mr. Speaker, as well as even a clerk of the court, Mr. Speaker. And I'm grateful that my friend from Bataya San Juan would have identified that the justices of the peace, as we speak, Mr. Speaker, are paid $30 a day, $1,000 a month, and $3,000 a quarter, and they apply for it on a quarterly basis. So therefore, the protection in terms of security of tenure, the issues as it concerns how JPs carry about themselves and carry out their duties, Mr. Speaker, are one that are legitimate. They are legitimate concerns, Mr. Speaker. And we don't come here to oppose for opposing's sake, but we are asking, in light of these circumstances, in light of some of the very same issues that my friend from Bataya San Juan would have identified, that currently treats with the justice of the peace and the way that they carry about their duties and some of the restrictions and so on, that why not wait until, in terms of only the justices of the peace, increase the amount of persons and category of persons who can grant search warrant, issue search warrants. So you're increasing from the 12 masters, and you're going to all the magistrates in the 13 magisterial districts in Trinidad and Tobago, which are over 100 magistrates, Mr. Speaker. You're talking about tens of registrars, in the magistrates court as well as in the Supreme Court. You are talking about the clerk of different clerks of the different magisterial districts. That is a wide category of persons where a police officer who has a reasonable or a reasonable suspicion that a crime is about to be committed, or a crime, some sort of evidential, some sort of evidence may exist in a particular house or business or whatever the case may be, can simply apply to these class of persons, which will drastically increase the amount of persons who can consider it, as well as, Mr. Speaker, drastically reduce the amount of time it takes for a warrant of these natures to be considered, granted, and issued. We have no objection on the side to that, Mr. Speaker. Mr. Speaker, what is the process to become a GP? And my friend from both Port of Spain South as well as Bataya San Juan would have outlined basically that it's almost as if it's a layperson. The application, now the Ministry of Attorney General Legal and Legal Affairs under the last administration, then moved to the Ministry of Legal Affairs, then last Saturday moved to the Ministry of Land and Legal Affairs. Mr. Speaker, the Justice of the Peace only has to provide the letter of application to the Honourable Minister of Land and Legal Affairs, have a recent resume with 2 references, have some qualification and or experience in the legal field, and Mr. Speaker, it has been the practice that mere certificates, sometimes 5-week certificates in certain courses, may satisfy that. And of course, copy of ID and a letter of recommendation, Mr. Speaker. This is considered by the Office of the Ministry of Land and Legal Affairs. The inference by my friend from Bataya San Juan that it is the president that appoints the Justice of the Peace pursuant to the Summary Court Act is correct, but the inference that there is some discretion that the president has, Mr. Speaker, is disingenuous, because Section 80 of the Constitution of the Republic of Trinidad and Tobago, Mr. Speaker, dictates that when in the exercise of the president's function under this Constitution or any other law, the president shall act in accordance with the advice of the cabinet or a minister acting under the general authority of the cabinet. Therefore, Mr. Speaker, it is on the advice of the member for Bataya San Juan that possibly political appointments could be made for justices of the peace. And I want to mark a spot there, Mr. Speaker, because it has been, Mr. Speaker, a certain kind of conduct since April 28th by this administration.
Mr. Speaker, Standing Order 48.6, please.
Well, more than 48.6, unless you can correlate the conduct which you refer to without particularizing it to the provisions of this bill, I think we need to move on, member.
Mr. Speaker, thank you very kindly for your guidance. The Justices of the Peace. This bill proposes for the Justices of the Peace to be able to consider, grant, and issue search warrants pursuant to JIPA. That's a fact. It is very relevant, Mr. Speaker, to have, as part of this discussion, what is the process for appointing justices of the peace, to consider whether they are the appropriate class and categories of citizens that should be administering this level of justice. And I therefore did not impute any improper motive against my friend from Bataria Sano. And I would not. But Mr. Speaker, the fact remains that my friend from Bataria Sano is a political office holder. And therefore, if it is on the advice and the president has no discretion whatsoever pursuant to Section 80 of the Constitution, then it is relevant to determine what are the considerations that is put before the member for Bataria Sano. Plain and simple. Mr. Speaker, the Honorable Attorney General also indicated that, and my friend from Bataria Sano also spoke about the comparisons to jurisdictions such as Canada, the UK, New Zealand, Australia, and other Caribbean and some other Caribbean countries relative to the considerations. Mr. Speaker, I just want to look at Canada. The Canada's Justice of the Peace Act, subsection 2, subsection 1.1 and 1.2, 1.3. Mr. Speaker, what does Canada provide in terms of the necessary to become, Mr. Speaker, a Justice of the Peace? Mr. Speaker, apart from the training, Mr. Speaker, that is required, the person must have a degree. They must be in good standing. They must have experience in the legal fraternity, please, Mr. Speaker. And therefore, that person is qualified to administer this judicial discretion. In the UK, there are similar laypersons' qualifications. However, there's training for the Justice of the Peace, and there's also provisions that if a Justice of the Peace in the UK is bankrupt, that they can't apply. There's no such safeguards or protection in Trinidad and Tobago, especially when you are paying a JP $1,000 a month. Mr. Speaker, in New Zealand, the JPs are required to undergo face-to-face and virtual training and an online test in order to qualify. Mr. Speaker, in Australia, there are pre-appointment training courses that last for 15 weeks for Justices of the Peace in training them what factors to consider in issuing and in granting and issuing the search warrants. So I'm just saying that it is a pattern that in Trinidad and Tobago, when we want to compare jurisdiction, we must understand the responsibility that comes with it. And my friend from Bataria San said that he came into the ministry and it was in a mess and it had no work going on. Mr. Speaker, I spoke to a member of the Justice of the Peace, the Justice of the Peace Association. And one of the first things that they told me in preparation for same, and one of the first things, Mr. Speaker, that I was told is that there was and this was my information, Mr. Speaker, that there was work being done by, it was spearheaded by the then minister in the Ministry of the Attorney General and Legal Affairs, the Honorable Renuka Sagram Singh Suklal at the time, where the Law Reform Commission was directed and in fact started the work in terms of looking at the system of Justice of the Peace and how they can amend it. So it is disingenuous, Mr. Speaker, and I confirm, Mr. Speaker, from the former Attorney General, Senator Faris Alwari, Mr. Speaker, that in fact did happen, Mr. Speaker. So it is disingenuous for my friend from Bataria, San Juan, to come and read work that was presented.
Imputed improper motives. 48-6. 48-6.
You did a remedial class, or you didn't call it.
You know, San Fernando East, you are the most chronic complainer of crosstalk.
Sorry, sir, there was no standing order as per the rules of this parliament.
You're the most chronic complainer of crosstalk. So let's stop it. Member, continue. But cut down the invective.
Cut down what, Mr. Speaker? I didn't hear.
The invective.
Deeply grateful, Mr. Speaker, and I'm guided, Mr. Speaker. Mr. Speaker, I don't know what is the obsession with the minister from Toko Sangre-Grande, who just seems to interrupt. There's no need for him to do it every time you make a ruling, Mr. Speaker.
Yes, but there's no need for that.
I stay silent every single time.
Just continue. Don't be distracted.
Deeply grateful, Mr. Speaker. Mr. Speaker, we are urging the Honorable Attorney General and the government to consider implementing and passing this amendment without the justice of the peace being included, that consultation be had with the relevant stakeholders that this act can apply to and will affect, and come back to the House at a later date, Mr. Speaker, so that we can consider whether we want to either, as it stands, allow justices of the peace to grant and issue search warrants, or if, as my friend from Bataya Sanwan said, it's a work in progress in terms of revamping the system and improving it, perhaps, Mr. Speaker, it may be wise to have that amendment when such work is completed, Mr. Speaker. Mr. Speaker, there are too many serious concerns about the conduct of justices of the peace in this country. And wise, I must say, Mr. Speaker, that the vast majority of justices of the peace may be ethical, may have some training, may have some experience, and may be able to carry out their duties in an impartial, fair, and justifiable manner. The reality is, Mr. Speaker, that there are too many instances before the court and in the public domain where not only allegations but evidence in different criminal proceedings where justices of the peace are not only rubber stamping warrants, but where there were justices of the peace issuing search warrants without even name and address, giving it to the Trinidad and Tobago, some officers of the Trinidad and Tobago Police Service, and they put the name on it when they want to enter your home. Mr. Speaker, we have to stand as watchdog against that kind of behavior. And we have to, Mr. Speaker, and we have to stand as watchdogs of that kind of behavior, especially when there is inference of political persecution from members opposite. When they point at,
Mr. Speaker,
Mr. Speaker, 48,
sit down. Sit down. Sit down. Sit down. With your nonsense. Mr. Speaker.
Okay. Leader of government business. Okay. Enough. Enough.
Mr. Speaker, that hooliganism will not be accepted. As per our standing order 48-6.
You know, there's absolutely no need for all of this. There's absolutely no need. Port of Spain South, I'm seeing you and you're laughing. I really would appreciate if we do not stand when other members are standing, especially when I am standing. And more especially, I would really, really be grateful if you in particular, and I really don't mean to single you out, but you in particular, to stand and shout in such an uncontrollable and venomous and vehement manner. Hold on. This is not how I know you. And you and I have very deep history of appearing together and against each other. I have never seen this outside of this forum. And I really would wish that we just simply stop it. If I could invoke the famous words of the Reverend Chubby Fabister David, stop it, all of you all. This needs to stop. No, I'm not inviting you to address me. All right. I'm not inviting you to address me. I'm going to allow the member, he's just run out of his time, but this is not fair to him. I'm going to allow you the 5 minutes we just took. I'm going to give you to 3:45, but I'm going to ask you, please, stay relevant, stop the imputation, stop the denigration and defamation and disparagement when you have absolutely no need to do so. This is a sterile bill, and we seem to be forgetting the principle that the justice of the peace is the most ancient judicial office to ever exist in the common law world. Justices of the peace have been providing quasi-judicial services for hundreds of years. As a matter of fact, the historical antecedents of justices of the peace was that they were the first responders in the United Kingdom when the judicial system was not unified and was spread out all over in a disjointed way. So let us forget the invective. Let us forget the pugilistic posturing and get on with it. You have 5 minutes.
Mr. Speaker, I thank you very kindly for your intervention. And I want to say, Mr. Speaker, that relative to that exchange, that I apologize to your chair. Because there's no way that the member for Cooper South was getting an apology from me, Mr. Speaker, for that conduct. Mr. Speaker, the fact of the matter is that there are serious vulnerabilities as it relates to giving the justices of the peace the judicial discretion to issue search warrants for indictable and matters that are triable either way, and going back on that dangerous road, Mr. Speaker. Mr. Speaker, whilst I appreciate your comments about justices of the peace and how we should protect and understand the whole history of justices of the peace, Mr. Speaker, I am, as an elected member of this House, Mr. Speaker, will continue to raise the concerns of my constituents, to raise the concerns of the people of this country. Yes. I was elected here, Mr. Speaker. I have standing to give views in this matter. Yes. And every 41 member of this chambers have the authority to exercise and express our views on matters coming for debate. The 41 of us. And the Attorney General, Mr. Speaker.
48-1 relevance, Mr. Speaker. Nobody's stopping the member.
Let's not just take up more time. The member has 2 minutes again. I trust he will paint between the lines.
Mr. Speaker, I don't understand it, Mr. Speaker. Mr. Speaker, Mr. Speaker, collateral damage library. Collateral damage library.
48-1, please, Mr. Speaker.
You see?
Wasn't me.
You see? It's the same point I was making. Gave you your 5 minutes. You've now resorted to name calling. The same thing you complained about. You've now resorted to name calling. Now tell me how that is productive. How does that assist us in moving forward? This incessant hurling and cross-hurling of insults, this never-ending desire to insult each other across the aisle, how does that help the conduct of the business of the House? Your 45 minutes is up, but I'll give you 1 minute.
Very kindly, Mr. Speaker. Mr. Speaker, Mr. Speaker, I want to thank you for the opportunity to contribute. I want to urge the Honourable Attorney General to consider the Justice of the Peace being removed. We would circulate an amendment to the effect of same, please, Mr. Speaker. And once the proper consultation is carried out, the opposition is prepared at that time to support wholeheartedly this effort once the views are heard and expressed. Mr. Speaker, with that few words, I thank you very kindly for the opportunity.
Honourable Attorney General.
Mr. Speaker, it has taken us the better part of 3 hours, close to 3 hours, to debate a bill which has 4 clauses and one which is entirely uncontroversial. And it is uncontroversial because every other Commonwealth Caribbean country, from Guyana in the south to Jamaica in the north, has precisely the provision which we are seeking to put into the legislation. Now, I reject the focus on what I describe to be elitism. The fact that because someone is not trained in the law, they can play no role whatsoever in the administration of justice. There is no country in earth where that obtains. In the United States, you have a grand jury. The grand jury is made up of who? Lawyers? People with qualifications? Masters? Registrars? The answer is no. And some of my friends on the other side, some of them went to law school, and they know this. So that I reject that notion. Now, I also reject the idea that ordinary citizens who are doing the best that they can do by other citizens should not play a role in the justice system. It is elitism, it is wrong in principle, and we were wrong, you were wrong in this House when you came here in 2023 and sent all of these justices of the peace away in favor of what you described to be a system where you had 3 masters. How does that work in a country with 1.4 million people? Mr. Speaker, if we, I've read out before the territories, all of the territories in which we have justices of the peace given search warrants in respect of indictable offenses. I've read it out. I'm not about to do it again. But what I want to say is that, and I'm not singling out anyone in particular, I'm not doing that this afternoon. I'm just speaking in general terms. Say again? Yeah. But some people said we have no statistics, but they quoted statistics. So what they said was that we had moved from a system where we had 3 masters to one where we have something like 11. And then Sotovoshi, they said 12. Well, let's say 12. Now, the point is, well, you have 2 points there. How on earth are we going to properly see that you have 12 masters and therefore you are managing this system efficiently? Our job is to, as members on this side keep saying all the time, we have to get the job done. But I could tell them we have 106 at least justices of the peace. More than that, because they are paid a small honorarium. And they are paid that between the Minister of Legal Affairs, I hope it is coming out of his budget, and the Office of the Attorney General. I don't know who these people are. Why do you see a gun behind every shadow? Is it that someone said, you know, they might be going to war with you? You're looking for guns all over the place? Just relax. This is benign. It is a piece of legislation which is carrying us to a point where we are using functionaries who are well known to the law, present all over the world, doing exactly what we are asking them to do. Now, you have to ask yourself a couple of questions, though. And these are the questions that I would like to know. Why is it that you sat in government from 2015 to 2023, a year before elections, and then you decided in 2023 that this system, not broken, but all of a sudden, search warrants are going to be very, very, very difficult to get. I'm asking the question. I'm not answering it here. So you sit in government for between 2015 and 2023, when search warrants are easy to get. A year before you leave office, you can't get a search warrant, right? Why is that? I don't know. I'm just putting it out there. And then they have the temerity to talk about, well, tell me what is going on elsewhere. In Jamaica, you have 11,000 justices of the peace. 11,000. Nobody is saying, well, you know what? They didn't go to law school. They didn't come first in law school. They didn't do this. So therefore, they should not be acceding to search warrants. Nobody is saying that in Jamaica. You know why? Because they are now getting the job done. Mr. Speaker, I just want to, a lot of talk has been made of the Brent Thomas case this afternoon. And I must say that I was surprised. I mean, my colleague and friend, Minister Hussain, used stronger language. But I was surprised to hear anyone opposite talk about Brent Thomas. Because, Mr. Speaker, I just want to read a few, two, not literally a few, two passages from Brent Thomas, and then to see what I am going to be doing. Okay? At paragraph 139 of the decision, the learned judge says, the first claimant was abducted. Now, the last time I checked, we had a law against that. Abductions. It's called kidnapping. And it's a serious offense. For all of us, lawyers, JPs who may not be trained in the law, all of us know abduction is a crime. The judge says the first claimant was abducted unlawfully in Barbados on the 5th of October 2022 and returned to Trinidad in the custody of ASP Birch, SS Martin, Officer Joe Field, and then he concludes with a sentence. That is an uncontroversial fact. That's what he says. It brooks no argument. The judge says so. That is so. 15 paragraphs down, he says this about the Attorney General, and I happen to be in that office now. He says, the Attorney General is, to my mind, the gatekeeper of the Constitution on behalf of the state as a whole, and is properly empowered with the appropriate jurisdiction to respond on behalf of the state. This is where the locus point, where a constitutional challenge has been raised. It would be the duty of the state, through the Attorney General, to gather the evidence from the appropriate quarters to not only answer and justify the actions of one arm of the state, but to also ensure compliance with certain orders. Now, if the Attorney General is to investigate, I take my job seriously. This is not a threat. I have started to investigate.
Yes, ma'am. Good.
And why have I done it? Because the judge, the High Court judge, tell me to do it. Nobody else. Nobody is going to war here. The High Court judge said, investigate. And I'm going to investigate it. And he also says, after gather evidence, I am going to gather the evidence. And lastly, he says that I have to justify it. Well, if it cannot be justified, then I'm sure that Mr. Alexander and his people will take the necessary, the Minister of Homeland Security will take the necessary action. That is not a threat. All that it is me saying that I am acting in obedience to the courts of the land. Mr. Speaker, I commend the bill to the House. It is uncontroversial. It seeks to give justices of the peace the respect that they deserve. It seeks to allow for search warrants to be obtained in an easier fashion by justices of the peace. That will be done when this legislation is finally passed. I recommend the bill to the House. Mr. Speaker, I beg to move.
Honourable members, the question is that a bill entitled An Act to Amend the Administration of Justice Indictable Proceedings Act 2011, Act number 20 of 2011, be now read a second time. Those in favour say aye. Aye. Those against say no. The ayes have it.
An Act to Amend the Administration of Justice Indictable Proceedings Act 2011, Act number 20 of 2011.
Honourable Attorney General.
Mr. Speaker, in accordance with Standing Order 68-1, I beg to move that the Administration of Justice Indictable Proceedings Amendment Bill 2025 be committed to the Committee of the Whole to be considered clause by clause.
Honourable members, the question is that the Administration of Justice Indictable Proceedings Amendment Bill 2025 be committed to the Committee of the Whole to be considered clause by clause. Those in favour say aye. Aye. Those against say no. The ayes have it. This House shall now go into Committee of the Whole to consider the bill clause by clause.
Clause 1.
The question is that clause 1 stand part of the bill. The question is that clause 1 now stand part of the bill. Those in favour say aye. Aye. Those against say no. The ayes have it. Clause 1 now stands part of the bill.
Clause 2.
The question is that clause 2 stand part of the bill. The question is that clause 2 now stand part of the bill. Those in favour say aye. Aye. Those in favour against say no. The ayes have it. Clause 2 now stands part of the bill.
Clause 3.
The question is that clause 3 stand part of the bill. The question is that clause 3 now stand part of the bill. Honourable Attorney General.
I've circulated an amendment, Mr. Chairman, the purpose of which is to carry forward the policy. To carry forward the policy of the bill to include justices of the peace in respect of the ability to get the search warrant. That's it.
That's it.
AG, I observed you circulated an amendment to the bill that was originally before the House. I'm trying to understand, the circulated amendment that you've just put before the House. Can I ask what is the main difference between the circulated amendment and the amendment that is before the House? The bill that is before the House originally.
Okay. we spoke essentially simply to the justices of the peace. Now, there is, as I understand it, a consequential amendment that is required to, I'm not seeing the clause in my consolidation, and that is what is, if you just give me a second.
Correct.
Okay. If you look at the original bill,
Yes.
not sure that do you have it? Yeah. The bill that we are amending. The section that was in the original bill reads, notwithstanding any written law which provides for a magistrate
Yes.
or magistracy, registrar, and clerk of the court magistrate to have or exercise jurisdiction in relation to any matter, A, referred to in subsection 1.
Okay. So I observed that.
Or
sorry.
B, for which a master is given jurisdiction under this act. And
Yes.
then we've amended it to include justices of the peace.
Yes.
In respect of 1A, 10(1)A, the power to issue search warrants.
Yes. So I observed that in the circulated amendments, I am assuming, Mr. Chair, that that is what we are considering, the circulated amendments.
Correct.
That by yes, thanks. Yes. By deleting the words magistrate, in inverted commas, or a magistracy, registrar, and clerk of the court, close inverted commas, in both places where they occur, and substituting the words magistrate, comma, a magistracy, registrar, and clerk of the court, or a justice of the peace, close inverted commas, in each place.
Correct.
So it's just the or that is removed.
Yeah.
Yes.
No, we are adding justice of the peace.
Okay, yes, yes, yeah. Yeah.
Okay.
Yeah, so I was just trying to get confirmation what was the difference between the original bill that we debated and the circulated amendment. So I fully understand.
Okay.
Thank you.
Thank you. I believe you have an amendment too, right?
Yes, so we had circulated, Mr. Chair.
Yes.
Yes.
There was an amendment which was circulated to all members.
By the opposition.
By the opposition. And I think if we could just explain it very quickly so we could get on with it. It simply proposes to delete the words or justice of the peace.
Absolutely, yes.
In both places, in both subclause 3B and subclause 3C2. Okay, so what I propose to do, subject to everyone's agreement, general agreement, is put the question with regard to the amendment as circulated by the opposition first, and then I'll put the amendment as circulated by the Honorable Attorney General second.
Yes.
I think this is a tidy way of doing it. All right, so the question is that the clause be amended in accordance with the amendment as circulated by the opposition and under this hand of the Honorable Chief Whip, the member for Aruka Lopino. Those in favor say aye.
Aye.
Those against say no.
No.
The ayes have it. The noes have it, sorry. I beg your Yes. Laventille West, I see you've regained your enthusiasm. Yes, I note your disclaimer, San Fernando East. Very, very poignant. Yes. So The question is that the clause be amended as circulated by the Honorable Attorney General. Stand part of the bill. Those in favor say aye. Aye. Those against say no. No. And carefully this time, the ayes have it. Clause. Right. Honorable members, the question is that clause 3, as amended in the terms circulated by the Honorable Attorney General, now stands part of the bill. Those in favor say aye. Aye. Those against say no. The ayes have it. Clause 3, as amended in the terms as circulated by the Attorney General, now stands part of the bill.
Clause 4.
The question is that clause 4 stand part of the bill. The question is that clause 4 now stand part of the bill. For economy of time, again, there is an amendment circulated under the hand of the Chief Whip, the Honourable Member for Aruka Lupino. And again, for economy of time, it simply seeks to delete the word justice of the peace. Are there any attendant comments anyone would wish to make, or shall I just simply put the question? Thank you. The question is that clause 4 be amended in terms as circulated by the Honourable Member from Aruka Lopino. Those in favour say aye. Aye. Those against say no. No. The noes have it. We go now to the Honourable members, the question is that clause 4 in its original form now stand part of the bill. Those in favour say aye. Aye. Those against say no. The ayes have it. Clause 4 in its original form now stands part of the bill. Honourable members, the question is that the bill, as amended, be now reported to the House. Those in favour say aye. Aye. Those against say no. The ayes have it. The bill as amended will now be reported to the House. Honourable Attorney General.
Mr. Speaker, I wish to report that the Administration of Justice Indictable Proceedings Amendment Bill 2025 was considered in the Committee of the Whole and approved with amendments. I now beg to move that the House agree with the committee's report.
Honourable members, the question is that this House agree with the committee's report on the Administration of Justice Indictable Proceedings Amendment Bill 2025. Those in favour say aye. Aye. Those against say no. The ayes have it. Honourable Attorney General.
Mr. Speaker, I beg to move that a bill entitled An Act to Amend the Administration of Justice Indictable Proceedings Act 2011, Act number 20 of 2011, be now read a third time and passed.
Honourable members, the question is that a bill entitled An Act to Amend the Administration of Justice Indictable Proceedings Act 2011, Act number 20 of 2011, be now read a third time and passed. Those in favour say aye. Aye. Those against say no. The ayes have it. A division having been called for, I have no discretion to say yes or no. The clerk will take the division.
You could call it anything. Mr. Padara,
Yes.
Mr. Tanku,
Yes.
Ms. John,
Yes.
Dr. Munilal,
Yes.
Mr. Lee,
Yes.
Mr. Hussein,
Yes.
Ms. Amin,
Yes.
Mr. Alexander,
Yes.
Mr. Maharaj,
Yes.
Ms. Mohit,
Yes.
Mr. Sturge,
Yes.
Dr. Bodo,
Yes.
Dr. Dowlath,
Yes.
Dr. Ali,
Yes.
Mr. Morris,
Yes.
Ms. Benjamin,
Yes.
Mr. Sobers,
Yes.
Mr. Watts,
Yes.
Dr. Sicharan,
Yes.
Mr. Kisa,
Yes.
Mr. Elder,
Yes.
Mrs. Sam,
Yes.
Mr. Narayan Singh,
Yes.
Dr. Rup Narayan,
Yes.
Dr. Gosain,
Yes.
Mr. Thomas,
Yes.
Mr. Sampson,
Yes.
Mr. Gonzalez,
No.
Mrs. Beckles Robinson,
No.
Mr. Imbert,
No.
Dr. Gadsby Dolly,
No.
Mr. Stuart Young,
No.
Mr. Scotland,
No.
Mr. De Nobrega,
No.
Mr. Manning,
No.
Mr. Marcel,
No.
Mr. Devines,
No.
Mr. Birchwood,
No.
Mr. Romaine,
No.
27.
Honorable members, I am to report that the results of the division is that 27 members voted in favor of the bill, 12 members voted against, and there were no abstentions. The bill has been passed 27-12.
A bill entitled An Act to Amend the Administration of Justice, Indictable Proceedings, Act 2011, Act number 20 of 2011. Motions?
Minister of Homeland Security.
Mr. Speaker, I beg to move the motion number 1, standing in my name. Mr. Speaker, I move this motion as I seek leave of the House in accordance with Standing Order 51 to debate alongside this matter motion number 2 on the order paper, both of which are integral. Interrelated, sorry.
Is this the wish of the House?
Yes, Mr. Speaker.
Honourable members, leave has been granted for motions 1 and 2 on the order paper to be debated interrelatedly.
Yeah.
Minister of Homeland Security.
Yes. Mr. Speaker, whereas Section 123, 1A of the Constitution of the Republic of Trinidad and Tobago, the Constitution provides that the Police Service Commission shall have the power to appoint persons to hold or act in the office of Commissioner of Police and Deputy Commissioner of Police. And whereas Section 123(3) of the Constitution provides that the Police Service Commission shall submit to the President a list of the names of persons nominated for appointment to the office of Commissioner of Police and Deputy Commissioner of Police, and whereby Section 1234 of the Constitution provides that the President shall issue a notification in respect of each person's nominated under Section 3, and the notification shall be subject to affirmative resolution of the House of Representatives. And whereas the Police Service Commission have submitted to the President of the names nominated to act in the office of the Commissioner of Police, Mr. Junior Benjamin, Deputy Commissioner of Police, and Mr. Kurt Simon, Acting Commissioner of Police, to act in the office of Deputy Commissioner of Police. And whereas the President has on the 3rd day of October 2025 issued a notification in respect of the nominations. And whereas it is expedient to approve the nominations, be it resolved that the notification of the President of the nomination by the Police Service Commission of Mr. Junior Benjamin to act in the office of Commissioner of Police, and the notification of the President of the nomination by the Police Service Commission of Mr. Kurt Simon to act in the office of Deputy Commissioner of Police, both be approved. Mr. Speaker, Alistair Govero, Commissioner of Police, will be attending the International Association of Chiefs of Police annual conference and exposition in Denver, Colorado, during the period 18th of October 2025 to the 21st of October 2025. This conference is noted for being the largest and most impactful law enforcement gathering for the year, attracting over 16,000 public safety professionals. The IACP provides a platform for networking in professionalism development, policy discussions, and access to new technologies and best practices. As a government, Mr. Speaker, as the government of the Republic of Trinidad and Tobago remains steadfast in its commitment to significantly reduce crime and criminality over this country. We continue to recognize the importance and empowering the leaders of the Trinidad and Tobago Police Service with the tools, the authority, the vision that is necessary to drive an impactful change. In this regard, the government is pleased to announce the appointment of Mr. Junior Benjamin to act in the office of the Commissioner of Police for the period October the 16th, 2025 to October 22nd, 2025, and also Mr. Kurt Simon from the 16th of October 2025 to the 22nd of October 2025. Mr. Speaker, Mr. Benjamin and Mr. Kurt Simon, they are no strangers to this Parliament. Mr. Benjamin is a highly accomplished and strategic law enforcement executive with more than 36 years service. His dedication to service in the Trinidad and Tobago Police Service, his distinguished career has given him the opportunity to be appointed Commissioner of Police from February 6th, 2025 to June the 7th, 2025, during which he provided exemplary leadership and operational oversight during several major national events. Mr. Benjamin, Mr. Speaker, brings the role of wealth and understanding of his profession and the Trinidad and Tobago Police Service, that experience in strategic planning, operational command, public procurement, polygraphy, exams, and operational transformation. He currently served as the Deputy Commissioner of Police Administration, where he oversees key areas such as human resource, finances, training, and logistical support for the TTPS. He also holds an impressive portfolio of academic qualifications, including Master of Business Administration, Bachelor of Law, Postgraduate Diploma in Law Practice, a Bachelor of Science in Business Management, and a Diploma in Business Management. Mr. Benjamin, prior success in this role of Acting Commissioner of Police, along with his proven record of operational excellence and leadership, makes him well suited to assume this critical responsibility during the absence of Mr. Alistair Govero, who will be temporarily absent from office. The government intends to fully support Mr. Benjamin and also Mr. Kurt Simon. Mr. Kurt Simon, Mr. Speaker, is a career police officer with over 35 years of distinguished service in the Trinidad and Tobago Police Service. And as I said before, no stranger to this Parliament. He began his career in 1990 as a police officer and has since risen to the ranks, holding several senior positions, including Assistant Commissioner White Collar, Assistant Commissioner of North Central Division, and Deputy Commissioner of Police, Intelligence and Investigation. He currently served as Assistant Commissioner of Police Administration. Mr. Simon is an accomplished and well-educated law enforcement professional. He holds a master's degree in science, criminology, criminal justice, and at the University of the West Indies. He also did research in homicide investigations. Mr. Speaker, he also holds a Bachelor of Arts in Criminal Justice, Police Science, and from the College of Science, Technology, and Applied Art in Trinidad and Tobago, COSTAT. Throughout his career, Mr. Simon has earned the reputation within the Trinidad and Tobago Police Service for his professionalism, innovation, and problem-solving approach. Among his noble achievements, Mr. Speaker, I hereby recommend that this Honourable House appoint both Mr. Junior Benjamin to act Commissioner of Police and Mr. Kurt Simon to act Deputy Commissioner of Police. I beg to move.
Members, before I put the question for debate, it's literally 4:30 tea time, so can I defer putting the question until we return at 5:15? Well, I think I'll propose the question, and then when we come back. Honourable members, I shall now propose the question for debate. Be it resolved that the notification of the President of the nomination by the Police Service Commission of Mr. Junior Benjamin to act in the office of Commissioner of Police be approved. Honourable members, you are reminded that leave has been granted for motions 1 and 2 to be debated together. So shall we take the tea break now? We'll return at 5:15. This House now stands, sitting is suspended until 5:15. Thank you. Member for Aruka Lopino.
Thank you very much, Mr. Speaker. Mr. Speaker, this matter that is currently engaging the attention of the House is one that normally engages our attention from time to time because of our constitutional makeup. Whenever vacancies arise in the Office of Commissioner and Deputy Commissioner of Police. And that is set out in our Constitution, Section 1, 2, 3, 4 of the Constitution of the Republic of Trinidad and Tobago, where the Independent Police Service Commission notifies the President of a vacancy or vacancies that may arise from time to time, and the President, through, again, complying with the Constitution and the notices that were published in accordance with the Constitution, would provide a notification to the Parliament, and the Parliament debates the notification for approval or non-approval as the case may be. Mr. Speaker, the Honorable Member Fortuna Puna, the Minister of Homeland Security, presented the motion and essentially give the reason for the appointment of Mr. Benjamin and Mr. Junior Benjamin and Mr. Kurt Simon to fill vacancies in the office of Commissioner and Deputy Commissioner, because during a period of time, the substantive office holders will not be in office. But I want to read in the record of the Parliament, Mr. Speaker, if you allow me to, because we would have received the letters through the Parliament as to the reasons, setting out the reasons for the vacancies. By letter dated October the 3rd, 2025, the Office of the President wrote to the Clerk of the House, Mr. Caesar, and the subject of the letter, notification of nomination submitted by the Police Service Commission for acting appointments in the offices of Commissioner of Police and Deputy Commissioner of Police, the Trinidad and Tobago Police Service. And it provides as follows. I have been asked by Her Excellency Christine Carla Kangulu, ORTT, President of the Republic of Trinidad and Tobago, to forward for presentation to the House of Representatives 2 notifications issued by Her Excellency the President pursuant to Section 123 of Section 4 of the Constitution of the Republic of Trinidad and Tobago as follows. 1. Notification issued in respect of the nomination submitted by the Police Service Commission of Mr. Junior Benjamin, Deputy Commissioner of Police, for acting appointment in the Office of Commissioner of Police, and Mr. Curtis Simon, number 2, for acting appointment in the Office of Deputy Commissioner of Police. Mr. Speaker, please also allow me to read in the records of the Parliament the letter dated October the 2nd, 2025, from the Police Service Commission addressed to Her Excellency, and it reads as follows. Nomination for acting appointment in the offices of Commissioner of Police and Deputy Commissioner of Police, Trinidad and Tobago Police Service. And the letter provides the particular section in the Constitution, no need to mention it. But what is instructive is that in the first subparagraph, numbered 1, it stipulates as follows. Mr. Junior Benjamin, Deputy Commissioner of Police, for acting appointment in the Office of Commissioner of Police, Vice Mr. Alesta Guevara, Commissioner of Police, who will be attending the International Association of Chiefs of Police Annual Conference and Exposition during the period 18th of October 2025 to 21st of October 2025 in Denver, Colorado, United States of America, who would be absent from Trinidad and Tobago from the 16th of October 2025 to the 22nd of October 2025, and Mr. Kurt Simon, Assistant Commissioner of Police, for acting appointment in the Office of Deputy Commissioner of Police, Vice Ms. Suzette Martin, Deputy Commissioner of Police, who will be attending as well the International Association of Chiefs of Police Annual Conference and Exposition during the period 18th of October 2025 to 21st of October 2025 in Denver, Colorado, United States of America, and who also will be absent from Trinidad and Tobago from the 16th of October 2025 to 22nd of October 2025. Instructively, Mr. Speaker, the letter reads in the concluding paragraphs that Mr. Benjamin and Mr. Simon hold the number 1 position of the Order of Merit list established and maintained pursuant to clauses 4.2 and 5.2 respectively of legal notice number 277 of 2021 as amended by legal notice number 278 of 2021. And accordingly, the Commission submits the names of Mr. Junior Benjamin and Mr. Kurt Simon to Her Excellency as enclosed. And that's the reason why we are debating these nominations, Mr. Speaker, to approve or not approve the recommendations by Her Excellency. But Mr. Speaker, Mr. Junior Benjamin, is not no stranger to us here in this Parliament, because we would have somehow approved similar notifications for him to be appointed in the Office of Commissioner of Police, and as the Minister would have rightly indicated, he would have served in the Office of Commissioner of Police during the period February 6, 2025 to June 2025. And Mr. Kurt Simon, my recollection, when I served briefly as Minister of National Security, he also would have served as a acting Deputy Commissioner of Police for a period of time. I don't have the information, but both officers are career officers and would have moved up the ranks of the Trinidad and Tobago Police Service from Constable to Assistant Commissioner of Police to Deputy Commissioner of Police, would have served the country in senior executive level at the Trinidad and Tobago Police Service, appeared before Joint Select Committees of Parliament, and discharging their responsibilities in what I would regard as in a very professional manner. So there's nothing that the President would have provided to us here in the Parliament that would cause us to object to the qualifications of the two very senior officers of the Trinidad and Tobago Police Service, Mr. Benjamin and Mr. Kurt Simon, because they are well known to some of us who would have served in the previous Parliament and this Parliament. But, Mr. Speaker, we and the country, obviously, has to be reminded that we are in a state of emergency. It's not the reason for this debate, but we are asked to approve these nominations because vacancies will be created in the offices of Commissioner of Police as well as Deputy Commissioner of Police in the midst of a state of emergency. A state of emergency which was justified and called for by one of the office holders, the Commissioner of Police, who will now be going to Colorado, Denver, to attend this International Chief of Police conference. And Mr. Speaker, the country is yearning to find out from the government, because the Commissioner of Police simply cannot leave the country on his own. He has to seek the appropriate leave from his seniors, and I think from the Ministry of Homeland Security, to attend this conference. So someone, and some high office holder, I think the Minister, would have to give his objection or non-objection to the Commissioner of Police attending an international conference in the midst of a state of public emergency in Trinidad and Tobago, especially when the state of emergency was justified by the same Commissioner of Police. Mr. Speaker, we cannot take these things lightly. These are very serious matters. These are not ordinary times in Trinidad and Tobago. Our rights are being suspended because, based on information that we are all familiar with, the lives of senior persons in this country are under threat, and we have no information whatsoever whether the circumstances that justified a state of public emergency in Trinidad and Tobago have changed. But we have notifications before us here today with no sufficient or lack of justification by the Minister of Homeland Security simply to say, well, 600 people attend and networking and what have you. We have serious problems in Trinidad and Tobago today that requires the attention of the substantive office holder as well as the Deputy Commissioner of Police. There must be extraneous circumstances that will justify why a senior police or two senior police officers, one being the Commissioner of Police and the Deputy Commissioner of Police, to leave this country during the state of emergency without proper justification, simply to say that you want to associate with 600 people and you want a network. We need to do better than that, Mr. Speaker. We need to do better than that. And this is not about blowing air in a bag. It is serious matters. are serious matters, Mr. Speaker. You see, Mr. Speaker, we need to take our job seriously. And when we serve in office of ministers, we have to understand this is not no joke. It's just serious matters. To leave your office with a bag and come to Parliament, it says a lot about what is happening in one's brain, Mr. Speaker. Mr. Speaker, let me tell this country that, Mr. Speaker, we need some ask members to observe the standing orders. Mr. Speaker, during this state of emergency, we have 72 murders reported. 72 murders. 23 murders in the last 2 weeks, Mr. Speaker. And a triple murder last night. During a state of public emergency in Trinidad and Tobago. And that is where the opposition is taking issue, because this is a very serious matter. This is a very serious matter. So it cannot be
crime debate. Thank you. The issue is a simple one. It's either you're going to approve it or you're not going to approve it. That's the narrow issue. The narrow issue framed in the motion is that. Let's just move on and not introduce extraneous, borderline irrelevancy, hyperbole. So let's move on. It really is irrelevant to the central issue framed in the motion.
Mr. Speaker, I thank you for your guidance. But, Mr. Speaker, the point I am making in this notification, this Parliament, Mr. Speaker, the elected members of this House, and we in the opposition, we have a responsibility to scrutinize the nominations and the recommendations by the President on a very serious matter with the Commissioner, the Deputy Commissioner of Police being out of the country. And we are saying that it must be taken in the context in which we exist in this country, where we have serious and pressing issues before us, because the Commissioner of Police and the Deputy Commissioner of Police, Mr. Speaker, in order to attend this conference, would have had to receive the objection or non-objection from the office holder. And that's the point I'm making. That's the point I'm making. And therefore, Mr. Speaker, we are saying that we have pressing issues in this country, where office holders, senior office holders, should have taken all of these into consideration before allowing senior police officers, the Commissioner of Police and the Deputy Commissioner of Police, to leave this jurisdiction, Mr. Speaker. And Mr. Speaker, the point that where Mr. Benjamin is concerned, a career police officer, well experienced, would have served in the office of Commissioner of Police, the opposition has no objection to the experience and the suitability of Mr. Benjamin. The opposition has no objection to the suitability and the qualification of Mr. Kurt Simon to act as well in the office of Deputy Commissioner of Police. But, Mr. Speaker, to end on this point, we are saying that the issue of the state of emergency in Trinidad and Tobago should be one that should have weighed heavily on the decision to have those two office holders absent themselves from the jurisdiction at this point in time. I thank you, Mr. Speaker.
Member for Cuba South.
Thank you, Mr. Speaker. Mr. Speaker, I truly did not intend to enter today's debate, but I simply cannot allow the member for Aruka Lopino to raise some serious matters and not have the government respond to it. Now, clearly, Mr. Speaker, the hot air seemed to have escaped the bag and entered into the chamber. The honourable member for Aruka Lopino raised several issues, one being that during a state of emergency that was justified by the Commissioner of Police, the substantive commissioner and one of the deputies will be out of the country for a few days. Mr. Speaker, I want to assure the nation that over the next few days, while the substantive commissioner and deputy commissioner will be abroad, what will happen is that the nation will continue to see progress in the area of crime fighting, because this government has demonstrated that we have the political will to fight crime. Mr. Speaker, we are here today to deal with the notifications before the Honourable House concerning one, Mr. Junior Benjamin to act as Commissioner of Police, and Mr. Kurt Simon to act as Deputy Commissioner of Police, pursuant to Section 123(4) of the Constitution. Mr. Speaker, these matters are not mere formalities, and the government understands the seriousness of this. And therefore, I want to remind members of the opposition, it was the then and current member for Superior who assisted in formulating the policies that we have today that allows for the Parliament to scrutinize any acting appointment that has to be made to the office of Commissioner of Police or that of Deputy Commissioner of Police. That is the legacy of the member for Superior as it relates to parliamentary scrutiny. And that is why we are here today, Mr. Speaker. Mr. Speaker, I've said to you, these are not mere formalities. It goes to the very heart of our Constitution. And therefore, Mr. Speaker, today when we speak about the rule of law, we speak about the public confidence in the command of the Trinidad and Tobago Police Service. Mr. Speaker, I say that this government stands in support of the nomination of Mr. Benjamin and Mr. Kurt Simon, because we have every trust, faith, and confidence that the work that has been laid out by the substantive commissioner, particularly over the last few months during the state of emergency, is yielding results, and is yielding real, tangible results on the streets of Trinidad and Tobago. And while, Mr. Speaker, it may not be at the point, and it may not be statistically where we want it to be, we are starting to see, Mr. Speaker, those real, tangible results in terms of the drop in homicides, but also in terms of other serious crimes. Mr. Speaker, these notifications arise solely because of the official overseas engagement of the substantive Commissioner of Police. Commissioner Alistair Guevara has been formally invited by the Embassy of the United States of America to attend the International Association of Chiefs of Police, IACP 2025 annual conference and exposition to be held from October 18th to 21st, 2025 in Denver, Colorado. I can assure you, Mr. Speaker, that the substantive commissioner will not be on a golf course while murders continue in Trinidad and Tobago.
Mr. Speaker, 48-1.
I'm speaking over the appointment.
No, I think it's relevant. Well,
Golf course? Who playing on a golf course?
48.1 is not applicable. All the member is saying is that the commissioner will continue to be on the job. That's all he's saying.
Mr. Speaker, if I may clarify,
yes.
Speaking about the commissioner going and wouldn't be in a golf course is irrelevant. It's irrelevant to this appointment.
Hang on a second. Your objection is that 48.1 is employed? The member for Ruka Lupino spent a lot of time talking about the vacuum created with the absence of these two officers. All the members simply do is responding to say there's no vacuum created. That's all he's doing.
With respect, Mr. Speaker, that is all the members say. With respect, Mr. Speaker, the members speaking about a golf course having to do
yes, but it might be
with the appointment of a replacement for the Commissioner of Police.
Perhaps it may be the liberal use of some kind of irony sometimes is allowed in a debate. So let's continue, please, and move on. This is a narrow issue. The issue framed in the motion is very narrow. So let's continue and move on quickly, shall we?
Thank you, Mr. Speaker. Mr. Speaker, as I've indicated before, that the vacancy arises because of the substantive commissioner heading to Denver, Colorado during the period 18 to 21, 2025. And therefore, while Mr. Junior Benjamin is being positioned to act as Commissioner of Police, the government will continue to be in contact with the Minister of Homeland Security, the Minister of Defense, and others with the substantive commissioner, understanding, Mr. Speaker, that this commissioner is not going there for a joyride. He's not going there for a holiday. And therefore, when you have serious matters being addressed in terms of institutional changes within the TTPS that will bring about changes that will redound to the benefit of the people of Trinidad and Tobago in the spheres of training, Mr. Speaker, in the areas of technical cooperation, Mr. Speaker, in the areas of manpower, partnerships. Those are the tangible benefits that we see that the substantive commissioner will bring, but understanding that because the government is supporting Mr. Junior Benjamin, who is very experienced, who has acted in this position before, will continue to work hand in hand, even though the substantive commissioner is abroad. So therefore, the issues raised by the member for Aruka Lopino simply does not arise, Mr. Speaker. Simply doesn't arise. You see, Mr. Speaker, the 2025 program that Mr. Guevara will attend and which will create the vacancy for Commissioner of Police and Deputy Commissioner of Police features high-level panel and sessions on emerging security, threats, digital transformation, leadership, crime prevention, and international cooperation. Mr. Speaker, several countries around the world have already declared war, while the AG has declared war on others. Well, I would hope so, that you have. While the AG has declared war on others here in Trinidad and Tobago, you are looking at partnering with other nations who have also declared war on the drug trade, have declared war on gun trafficking, who have declared war on human trafficking. And therefore today, to say that the Commissioner of Police is going to the United States for a conference, leaving a vacuum here in Trinidad and Tobago during a state of emergency is the furthest thing from the truth. Instead, the partnerships that the substantive Commissioner of Police seeks to bring to Trinidad and Tobago will continue the work and the legacy that this commissioner, the substantive commissioner, and his colleagues, inclusive of one Junior Benjamin and one Kurt Simon, will bring to the people of Trinidad and Tobago and the fight against crime. Mr. Speaker, this government is not myopic in its approach. We understand that we need technical assistance, that we need to partner with others, and that is why when the commissioner indicated that he had received this information, there was collaboration with the commissioner in ensuring that we have the systematic approach that is much needed to continue the fight here locally. And that is why we can stand solidly as a government and say to you that while the statistics is not where we want it to be, it is going in the right direction, because it is going down, it is going down, and it is going down. And therefore it requires strong leadership. Strong leadership. It requires proven leadership. And therefore the government did not seek, like others, colleagues across the floor, all of a sudden, very pious. We know it's a holy season, but spare us the hypocrisy, Mr. Speaker. The member for Sipare did not go to President's house to intercept any merit list. Instead,
I rise on 48-1 once again. You yourself just said it was a very narrow point. I rise on 48-1. How is this subject matter relevant to what we are speaking about?
If you will allow me to proceed, member, can we move along on that? It's a narrow issue. Let's just move along.
Mr. Speaker, facts is a stubborn thing. And therefore, in terms of contextualizing why we are here today, one, and justifying the choice of the selection of the Police Service Commission, put squarely what the debate is about, which is before us. Because the only way we could have gotten the name Junior Benjamin and Kurt Simon is if the Police Service Commission had made the recommendations. And that was exactly the point that the member for Aruka Lupino made. And all I am simply saying is that we could have chosen to play politics with the appointment of these persons acting in these positions, or we could have chosen to derelict our duty. We could have chosen to hand select who we wanted, but instead, we did the decent and right thing, which was to choose the person to support who was most qualified, most competent to act in the position, and that is why we are here today, supporting the appointments of one Mr. Benjamin and one Mr. Kurt Simon. I cannot say the same for my colleagues opposite. And I heard the member for Barataria, San Juan, earlier said, they on the other side have one position when they're in government, and then they have another position when they are in opposition. They sat there quietly with sanctimonious hypocrisy, wanting to lecture this side.
I rise on 48.6, Mr. Speaker. I've sat in this House even today and heard all you have said and guided about the type of language and all of that you have, your guidance has been given to this side. I stand on 48.6 once again to speak about the way the members on this side are being referred to by the member for 48. 48, and so what happened in the Parliament? I can't speak.
48.6 is imputing improper motive. Doesn't apply. Move on.
Thank you, Mr. Speaker. Mr. Speaker, I think if members opposite spent more time inside of the chamber and less time in the tea room, they would know what's happening inside of the House, and they would know their standing orders better,
Mr. Speaker.
There's no need for that. That's just unhelpful. Let's just move on.
The participation of the Substantive Commissioner of Police has created the situation, as I said, that we find ourselves in today. But the member for Aruka Lupino made a big song and dance about the impact or the possible impact that the Substantive Commissioner's absence from the country may have on Trinidad and Tobago. I want to say, Mr. Speaker, to the national community that while one Mr. Junior Benjamin sits as acting Commissioner of Police, the Substantive Commissioner will be strengthening Trinidad and Tobago's visibility and reputation in terms of global policing networks. While one Mr. Kurt Simon will be sitting in the position of Deputy Commissioner of Police, the substantive DCP will be ensuring that we receive the support of the continued modernization of our law enforcement and intelligence capabilities and facilitate direct collaboration with international counterparts on digital security, officer welfare, and organizational resilience. Mr. Speaker, the government understands the need, the importance of the attendance of the Substantive Commissioner and DCP in attending these conferences in order to bring about the fruits that we have identified. And therefore, when you have well-qualified people, you don't have square pegs in round holes as we have seen in the former administration. You feel comforted in knowing that while Mr. Guevara and others are going abroad to bring back tangible things to assist in policing, in terms of networking, in terms of intelligence, in terms of surveillance, that you will have suitable persons acting in the interest of the people of Trinidad and Tobago and not acting in the interest of those who may, at one point in time, seek to put them in these positions for their own political self-narrowed interest. And that is what you will not have on this bench, Mr. Speaker. You will not have a prime minister inserting themselves while Mr. Guevara is abroad. And therefore, Mr. Speaker, I raise another issue, and that has to do with the constitutional and procedural context that we find ourselves in this debate. Mr. Speaker, in accordance with the constitutional process, the Police Service Commission acts under Section 1232 and 3 of the Constitution. My colleague Aruka Lopino spoke about Her Excellency issuing the notifications, and Parliament under Section 1234 gives its approval. Mr. Speaker, this framework exists to ensure lawful continuity of command while safeguarding the independence of the police service from executive direction. This House has debated similar notifications before, notably in 2018, and we all remember that meritless controversy, the 2021 selection process orders, and the February 5th, 2025 debate, when these same names, Mr. Speaker, these same names that are brought to the parliamentary notification today, in a previous incarnation came before us. Mr. Speaker, whether seated on that side of the chamber then or on this side today, our government members, Mr. Speaker, have consistently affirmed that Parliament's duty to scrutinize these appointments is a constitutional safeguard, and it is a safeguard that we are exercising today, as we did when we were in opposition. We are supporting that same safeguard today, Mr. Speaker. Mr. Speaker, the safeguard that it strengthens the process. It strengthens transparency, that it can be held up in terms of accountability to the people of Trinidad and Tobago when we swore up to uphold the Constitution and the law, Mr. Speaker. Mr. Speaker, it is often said if that one does not reflect on the past, sometimes we are doomed to repeat the mistakes of the past. Mr. Speaker, I want to remind that while we seek to empower Mr. Junior Benjamin and Mr. Kurt Simon, both as acting Commissioner of Police and then as DCP acting, on February 5th, 2025, a few months ago, the debate then guided us, and the reference is on the official Hansard record, of two key perspectives. One, from the former Prime Minister and then member for Diego Martin West, that these appointments originate with the Police Service Commission and not the government. It is very few times, I can't recall one instance at all, but on this occasion, Mr. Speaker, I reflect on the words of the former Prime Minister then, who reminded us that this process comes from the PSC and not the government. But, Mr. Speaker, Parliament's role is to confirm the lawful chain of authority from the PSC's decision through the presidential notification to the approval of this House. And this duty must be discharged free from political interference. So we have inherited this merit list coming from the Police Service Commission, but the onus now is on the government. And therefore the government, as I've said before, and I'm sure colleagues will agree with me, that we have every trust, every faith, every confidence in the exercise that we are engaged in here today, knowing that the safeguards in our Constitution and in the constitutional process allows and lends itself for the buy-in of the national population to understand that we are putting the right people at the right time without any political interference. And that is a stark difference in terms of the approach that this government is taking today under the member for Siparia compared to the last government under the member for Diego Martin West at that time. Mr. Speaker, on the second limb from the then and current member for Urupuch East, Parliament should also examine whether legitimate basis exists for the acting appointment under the PSC's own policy. I see the member for Urupuch East nodding in approval. And that is why I tell you, When we said it then, we stand by our position and we say it now. Mr. Speaker, the member had indicated that Parliament should also examine whether a legitimate basis exists for the acting appointment under the PSC's own policy. The member for Rapuch indicated it must verify that the process and documentation are in proper order, that the use of any order of merit list must meet standards that preserve public confidence. Must preserve public confidence. And therefore today, while we are asking the House to support the appointment of one Mr. Junior Benjamin to act in the role of Commissioner of Police, and DCP Simon acting, of course, in that position, it is to ensure that public confidence remains in the process. And that is what we are about from day one. And that is why proudly we can say that the Honorable Prime Minister, serving in a different capacity at that time, was one of the main architects. And therefore we hold true to the position when it was first brought about to now being in government, because we could have simply taken a very different approach. But Mr. Speaker, for far too often in our recent past, under former administrations who sought to undermine public confidence in the Police Service Commission, you are not seeing that today. You are seeing where we are saying that these two gentlemen who have appeared as number one on the merit list will get the government's support because they are astute, they are competent, they are qualified, and therefore we have no political horses in the race. The horse that is in the race is a horse that belongs to the people of Trinidad and Tobago. They do not wear the rising sun emblazoned on them. But Mr. Speaker, there was a time when members opposite was hoping that they would have worn a balisé like the tie that they wear today inside of the Parliament, seeking their own narrow interest. Mr. Speaker, the use of any order of merit list must meet standards that preserve public confidence. And such safeguards are vital during times of heightened security of the police service. And heightened security comes while we are in the middle of a state of emergency. That is not news to us, as a member for Aruka Lopino attempted to bring a lot of sound and fury and concern. The reason why we were so comfortable in supporting the appointment of Mr. Benjamin and Mr. Simon Kurt is that knowing during a state of emergency the safeguards that are vital during the times of heightened security, that the police service themselves must be able to demonstrate their impartiality and their ability to conduct themselves and their work without undue influence. Mr. Speaker, we see on this side of the House merit in both positions in the insistence on lawful process and in the demand for public confidence. In today's debate, our responsibility is therefore clear: not to rubber stamp, not to investigate, though the AG did promise some investigations today, but to ensure the law is observed and the chain of command preserved, all without compromising the independence of the Trinidad and Tobago Police Service. Mr. Speaker, there are three tests of today's notifications for Mr. Benjamin and Mr. Kurt. And to guide our deliberations, I propose three tests by which these notifications should be measured. Each reflects Parliament's duty to uphold the law, safeguard stability, and maintain trust. And that is what this is about. Test 1, lawfulness. The notifications are anchored in Section 123(4) of the Constitution and in the Commissioner and Deputy Commissioner selection process, Orders 2021, Legal Notices 277, 278 of 2021. The President's communication confirms that the PSC's nominations are for a clearly defined temporary period of absence. On this test, the notifications are properly before the House, Mr. Speaker. Mr. Speaker, test 2, continuity and capability. Mr. Junior Benjamin, as Deputy Commissioner, possesses the seniority and operational command experience necessary to act as Commissioner during this short period. Mr. Kurt Simon, Mr. Speaker, as Assistant Commissioner, is well placed to act as Deputy Commissioner, ensuring that no leadership vacuum in specialized divisions. And specialized divisions at this time during a state of emergency is very important to the operational limb of the Trinidad and Tobago Police Service, Mr. Speaker. And therefore, again, that is why we feel comforted, we are satisfied to lend our support to Mr. Kurt Simon, understanding that his role and function, separate and apart from the Acting Commissioner of Police, will lend itself to the operational issues. And that is why my colleague, Minister of Homeland Security, can stand boldly and proudly, Mr. Speaker, and tell you that while Mr. Junior Benjamin and Mr. Kurt Simon acts in these positions, they receive the support of the state in terms of the operational limb of the Trinidad and Tobago Police Service. And that is something that I cannot say that our colleagues, when in government, lend their support to.
If I may, I rise on stand another 55(1)(b). Mr. Speaker, this is tedious repetition. We've heard these points over and over and over again.
Well, I don't recall which member would have made that point. The mover of the motion spoke, the member for Ruka Lupino spoke, none of them made those points. Overruled. Continue.
Speaker, it's really a sad state of affairs that members come to this House and they don't prepare properly. They don't even read the notifications. Because, Mr. Speaker, I'm speaking about the Deputy Commissioner of Police.
Mr. Speaker,
I'm speaking about...
When I rose on 55(1)(b), I'm speaking of the member repeating himself tediously, ad nauseum, Mr. Speaker, round and round and round.
The member carefully laid out a three-pronged test. Continue.
Thank you, Mr. Deputy Speaker. Mr. Speaker, sorry. Mr. Speaker. Thank you. Mr. Speaker, do I have any additional time? For the interruptions.
Yes, you do. Go ahead.
Thank you, Mr. Speaker. Mr. Speaker, while we have spoken about instilling public trust and confidence in the Trinidad and Tobago Police Service, as well as the institution itself, I want to also say, Mr. Speaker, that while Mr. Benjamin and Mr. Simon acts in these positions, we give the assurance to the nation that there will be no executive interference in the Trinidad and Tobago Police Service operations. Mr. Speaker, we give the assurance that while Mr. Benjamin and Mr. Simon acts in these positions, the PSC and the DPP retain full constitutional independence and there will be no interference by any Prime Minister or Minister of Homeland Security. Mr. Speaker, we give the assurance to the nation that while Mr. Benjamin and Mr. Simon act in these positions, the government's role, and we understand it very clearly, is to provide a lawful framework, resources, and oversight, not to direct investigations or select officers. You would not get that from the side, Mr. Speaker. Mr. Speaker, within 60 days, the relevant ministers will table a concise written update on measures implemented during and after the acting period, and we give that commitment to the people of Trinidad and Tobago, including command handover, continuity of critical operations, and any process improvements identified. Mr. Speaker, for 10 years, we have had acting appointments come to the Parliament, and never once, under the authority of the Prime Minister and the Minister of Homeland Security, I am saying today, within 60 days, the relevant ministers will table a concise written update on measures implemented during and after the acting period, including command handover, continuity of critical operations, and any process improvements identified. and therefore we are able to measure the successes of those that we put to act, therefore having something to measure it against should another acting appointment come up, Mr. Speaker. And Mr. Speaker, these were the loopholes that today, while we seek to put an acting commissioner of police, a deputy commissioner of police, we are taking it one step forward, because this is a government that intends on being accountable to the Parliament and ultimately to the people of Trinidad and Tobago. And members opposite shake their head and nod, Mr. Speaker, knowing that you had in the former administration a Minister of Government, a Minister of National Security, saying to the population, my job is not to secure you. That was said on the public record. Today, this government is saying that while we seek to put Mr. Benjamin and Mr. Simon in acting positions, we, within 60 days, will measure the successes, or even if there's a lack of success, we will measure that and then report to the Parliament. If that is not performance, Mr. Speaker, I don't know what is. Mr. Speaker, today, Mr. Speaker, we speak about succession and capability in terms of measuring any acting appointments. And therefore, Mr. Speaker, we can speak of the assessment of the nominees. We could speak about the performance of the TPS under the current leadership. And I would like to take the opportunity, as Mr. Guevara, the substantive commissioner, prepares to go on international training and conference, to wish him the very best success. Because when Mr. Guevara and the TTPS wins, all of Trinidad and Tobago wins, Mr. Speaker. And anybody who is against that, Mr. Speaker, is seeking to serve their own narrow political interests. But the population has seen through that narrow political interest exercised by our colleagues opposite. And therefore, Mr. Speaker, when this administration took office in May 2025, we inherited 4,500 murders in a decade.
Mr. Speaker, I rise on 48-1.
Let's move on now.
Mr. Speaker, within months of assuming responsibility, while today the substantive commissioner and deputy are going to seek partnerships abroad that will assist us in terms of both the administration and the operations of the Trinidad and Tobago Police Service. They go so with the support of the government, Mr. Speaker, knowing that the persons that have been identified by the PSC will lend its support in terms of proper leadership and management of the Trinidad and Tobago Police Service at a critical time during the state of emergency. Mr. Speaker, over the past couple months, we have seen over a 56% decrease in some areas.
Mr. Speaker, I rise on 48-1 and 55-1B. You have heard this over and over again.
I never spoke about 56%
and you ruled that it was a narrow motion.
Yes, but it is a member for Aruka Lupino which opened the door. It is a narrow motion, but that door was open.
Mr. Speaker, you stopped him. You prevented him.
I stopped him on crime and murders, 23 murders in 3 days.
But that is what the member was speaking about, the crime rate and the number of murders, Mr. Speaker. I'm only using what you had ruled on.
Overruled. Just continue. Just skip along. Let's get on with it.
Mr. Speaker, as previously indicated, Mr. Speaker, you can run, but you cannot hide. You can run, but you cannot hide, Mr. Speaker, as the members of the opposition exit the Parliament, once more abdicating their duty to the people of Trinidad and Tobago, Mr. Speaker. We say to them, you can run, but you cannot hide. The people of Trinidad and Tobago will measure you today. The people of Trinidad and Tobago will measure you today by your lack of commitment to process. The people of Trinidad and Tobago will measure the opposition today as we see the empty benches, Mr. Speaker, As we see the empty benches, the member for Aruka Lopino is no longer with us. The member for Arima is never ever with us. The member for Diego Martin Northeast is gone. The member for St. Anne's East is gone. Well, we thought we would not have seen the member for Port of Spain North St. Anne's West after April 28th. He too is gone for another time, bowled out by the government. The member for Port of Spain South is gone. The member for Aruka Maloney is never here. The member for Diego Martin Central gone. The member for Diego Martin West gone. The member for Laventille East, Laventille West, all gone, Mr. Speaker, on an important motion. All. Abdicating their responsibility, their duty to the people of Trinidad and Tobago. Why? Because they did not have the political will to stand up here and contribute. Each member is allowed 45 minutes where you stand up and you give your contribution. You say why you're supporting or why you're not supporting. This government can tell you about the safeguards. We can tell you about the process. We can tell you about the constitutional support that we are giving. We can tell you about the member for Tunapuna, the member for St. Joseph, the member for Toko Sangre Grande, our own Attorney General who they're afraid to go to war with them. Having identified why, Mr. Speaker, identifying pellucidly identifying, I will not fall in that trap, identifying pellucidly why we have faith, trust and confidence in Mr. Benjamin and Mr. Simon. Mr. Speaker, on this side of the House, we're not using no person or persons in the TTPS to achieve any political objective. That is not the modus operandi of our colleagues opposite, and that is part of the reason why we are here. And they are there, but now they are gone, and the day will come. The day will come when the entire government under the member for Siparia will be sitting on this side of the House. Because they are wasteful, they are hypocritical, they have nothing to contribute. They have demonstrated that while they were in government, and today they are demonstrating that while they are in opposition, Mr. Speaker. Mr. Speaker, I want to once more indicate that the government is prepared to support the nomination of Mr. Simon as Deputy Commissioner of Police, acting Mr. Benjamin, and we want to congratulate Mr. Alistair Guevara and his brave men and women for the significant drop in the crime rate that we are seeing. A lot more needs to be done. But with their support, when they return, knowing that they will be properly trained, they will create partnerships abroad that will bring benefit to the people of Trinidad and Tobago. And when the TTPS wins, Trinidad and Tobago wins with the Honourable Member for Siparia, Prime Minister Kamala Persad-Bissessar. I thank you, Mr. Speaker.
Minister of Homeland Security.
Mr. Speaker, after my colleague would have spoken this evening, I realized that we are left with the ghost of time past.
Is that so?
Because clearly, Mr. Speaker, the member for Aruka Lopino didn't even realize that in this SOE there is no restrictions to persons because his leader was able to fly. And Mr. Speaker, let me also say this. During their SOE, a state prosecutor was murdered, but yet they continue to have this conversation willy-nilly. Mr. Speaker, I worked with both Mr. Benjamin in my past life and Mr. Simon, and I highly recommend them to the post of Acting Deputy Commissioner of Police and Acting Commissioner of Police. Mr. Benjamin and Mr. Simon, they are both correct police officers, and they will continue to hold the fort until the return of the Commissioner of Police and the Deputy Commissioner of Police. Mr. Speaker, I beg to move.
Honourable members, the question is, be it resolved that the notification of the President of the nomination by the Police Service Commission of Mr. Junior Benjamin to act in the office of Commissioner of Police be approved. All in favour say aye. Aye. Any against? I'm not sure. I just want to check whether division is available on a motion. Available on a motion? Yes, I'm advised, but yeah. Well, the clerk will take the division.
Present and yes.
Mr. Tanku?
Present and yes.
Ms. John?
Present and yes.
Dr. Munilal?
I'm here. Yes.
Present.
Mr. Lee?
Present and yes.
Mr. Hussain?
Present and yes.
Ms. Amin?
Present and yes.
Mr. Alexander?
Present and yes.
Mr. Maharaj?
Present and yes.
Ms. Mohit?
Present and yes.
Mr. Sturge?
In the house, and yes.
Dr. Bodo?
Present and yes.
Dr. Dowlat?
Present and yes.
Dr. Ali?
Present and yes.
Mr. Morris?
Present and yes, but where's the opposition?
Ms. Benjamin?
Present and yes.
Mr. Sobers?
Present and yes.
Mr. Watts?
Present and yes.
Dr. Sicharan?
Present and yes.
Mr. Kisa?
Present and yes.
Mr. Elder?
Present, represented people of Labrie, and yes.
Mrs. Sam?
Present and yes.
Mr. Narayan Singh?
Present and yes.
Dr. Roop Narayan?
Present and yes.
Dr. Gosain?
In the house and yes.
Mr. Thomas?
Most present and yes.
Mr. Sampson?
Present and yes.
Members, I am to report that the results of the division are 24 members voted yes. 27, sorry, I beg your pardon. There was 0 against and 0 abstentions. The motion to approve Mr. Junior Benjamin to act in the role of Commissioner of Police in the absence of the substantive office holder, Mr. Alistair Gavaro, is hereby approved. Minister of Homeland Security, can I now invite you to move the motion standing in your name, the motion number 2?
I thought both of them were in one.
Both of them was in one.
Advised by the staff who are far more accurate with this procedure than I ever am or will become. I'm advised that the second motion must be read into the record.
Mr. Speaker, motion number 2, I beg to move motion number 2 standing in my name.
Can I invite you to read the contents of the motion into the record?
Don't pack up already, Mr. Speaker. Look at here.
You got pack up already. Yeah. Yeah. All right. Listen. Yeah. Come here. Mr. Speaker, I beg to move motion number 2 in my name. Yeah. Whereas Section 123(1) of the Constitution of the Republic of Trinidad and Tobago, the Constitution provides that the Police Service Commission shall have the power to appoint persons to hold or act in the office of Commissioner and Deputy Commissioner of Police. And whereas Section 123(3) of the Constitution provides that the Police Service Commission shall submit to the President a list of names of persons nominated for the appointment to the office of Commissioner or Deputy Commissioner of Police. And whereas Section 1234 of the Constitution provides that the President shall issue a notification in respect of each person nominated under subsection 3, and the notification shall be subject to affirmative resolution of the House of Representatives. And whereas the President has on the 3rd day of October 2025 issued a notification in respect of the nomination, and whereas it is expedient to approve the notification, be it resolved that the notification of the President of the nomination by the Police Service Commission of Mr. Kurt Simon to act in the office of Deputy Commissioner of Police be approved. I beg to move.
Minister, can I, for the sake of the accuracy of the public record, can I just ask you to read into the public record the recital of the motion where the Police Service Commission has submitted the name of Mr. Kurt Simon as the person nominated to so act? This simply is for the accuracy of the public record, which Hansard stands. I'm afraid that outside of Hansard, it will not be reflected that Mr. Simon's name was actually submitted. So can I just invite you to read that one part before the resolution is put to the House?
And whereas the Police Service Commission has submitted to the President the name Mr. Kurt Simon, Assistant Commissioner of Police, as the person nominated to act in the office of Deputy Commissioner of Police. All right. Be it resolved that the notification of the President of the nomination by the Police Service Commission of Mr. Kurt Simon to act in the office of Deputy Commissioner of Police be approved. I beg to move.
Honourable members, the question is, be it resolved that the notification of the President of the nomination by the Police Service Commission of Mr. Kurt Simon to act in the office of Deputy Commissioner of Police be approved. All in favour, say aye. Aye. Any against? Let's take the division.
Mr. Padarav?
Present and yes.
Mr. Tanku?
Present and yes.
Ms. John?
Present and yes.
Dr. Munilal?
Present and yes.
Mr. Lee?
Present and yes.
Mr. Hussain?
Present and yes.
Ms. Amin?
Present and yes.
Mr. Alexander,
Present and yes.
Mr. Maharaj,
Present and yes.
Ms. Mohit,
Present and yes.
Mr. Sturge,
Present and yes.
Dr. Bodo, Dr. Dowlat,
Present and yes.
Dr. Ali,
Present and yes.
Mr. Morris,
Present and yes.
Ms. Benjamin,
Present and yes.
Mr. Sobers,
Present and yes.
Mr. Watts,
Present and yes.
Dr. Sicharan,
Present and yes.
Mr. Kisa,
Present and yes.
Mr. Elder,
Present and yes.
Mrs. Sam,
Present and yes.
Mr. Narayan Singh,
Present. Present and yes.
Dr. Rup Narayan,
Present and yes.
Dr. Gosain,
In the house and yes.
Mr. Thomas,
Present and yes.
Mr. Sampson,
Present and yes.
I should like to report the results of the division of members present in the House and voting. 27 members voted in favor of the motion, 0 against and 0 abstentions. In the circumstances, the motion asking for the resolution that Mr. Kurt Simon act in the office of Deputy Commissioner of Police in the absence of the substantive office holder is hereby approved.
Thank you kindly, Mr. Speaker. Mr. Speaker, I beg to move that this House do now adjourn to Monday, October 13th, 2025 at 1:30 p.m., where the Minister of Finance will present the 2025-2026 fiscal package to the nation.
Honourable members, the question is that this House do now adjourn to Monday, 13th October 2025 at 1:30 p.m. for the purposes as outlined by the Leader of Government Business. All in favor say aye. Aye. Any against? I think the ayes have it. This House now stands adjourned to Monday, 13th October 2025 at 1:30 p.m.